Were you only on the British Isles, or did you take the Channel and go to?
We didn't do the Channel. We did. We started out in London and then went up through the English countryside into Scotland for a few days, and then over to Kerry to Northern Ireland, and then into Ireland for a few days, and then ferried back over to Wales and back into London.
Wow, you saw it all.
Yes.
Huh.
It's very fun. Very
Excellent.
beautiful.
Well, good for you and your travel companion.
Remind me to vacation with you next time.
She clearly knows how to make it work. Huh. Willingham had a bad encounter out in the hallway. There was some dude just wearing a bathrobe and his underpants. Are we dealing with him? Okay. I won't ask what that means, but okay. You dealt with them. In a courthouse, how do you get through security? Come on.
He had a coat at first, but still, it's a.
Right. Was he wearing slippers?
Yeah.
Okay. Come on, security. Well, why don't we go? Let's see. Gotta make sure we get all right. That we got everyone we need. Well, good morning, everyone. Happy Friday. Exciting to have Ms. Wood back. That we actually had a betting pool as to whether she was just going to set roots down in Ireland or something and not return. We're glad you returned. I'm sure your inbox was very full. While you were gone, things shifted around a bit, and we will be in trial next week, not this week, on Mr. Tuitt. We have a jury, and that'll start on Monday. And so we're trying to move as much from next week to this week, hence this morning. But we will still be calling all the calendars, the 9 a.m. calendars, because there may be people who got notice to be here and they're on bond and they'll need to show up. You shouldn't call any clients to say, don't come in, unless it was a plea and arraignment and Ms. Nelson said, you file a waiver, everyone's excused. Those clients don't need to be here if they've been excused. So we'll be starting trial more like 9:15 or 9:30 each morning, other than Wednesday, which is drug court, while we call those calendars and see what happens. So what I've got is a case with Ms. Willingham and you, Mr. Astiero. Is he in custody? All right, that's why there's a booking number. I should get that. We've got Mr. Phillips, and that's going to be a bond hearing. All right. And that is with you, Ms. Davis, and Victor Gordon. Then we've got Jerry Diggs. Thank you. And Ms. Wood, that's you, and Ms. Nix. And you've got that look on your face. Oh, because this is the one I asked Ms. Nelson about. It says plea/motion for bond. Like, well, you don't need a bond if you're pleading. Is Mr. Diggs he has either some physical or mental health challenges?
He has physical. He's got an end-stage organ failure.
Okay, this is where we're getting some inquiries from the jail about could he not be here? Okay, well, we'll talk with you and Ms. Nix about that. Then we've got Jonathan Terry, who was the final plea next week. He is on the Zoom call.
Yes. He's ready to go.
Great. We have a suppression motion, but that got rescheduled because you have an officer who's executing a search warrant.
Yes.
I don't know the new date, but it's not today. Okay. I will cross that off. And then I've got as a 2:00, a plea with Ms. Willingham and Attorney La Scala. Mr. Johnson is listed there as well, but I think our goal is just to do him last, but this morning. I'm good till noonish, and then I'm back around 1:30. So if we don't get through, we get through all this morning stuff, especially with the motion not happening, we'll just do Mr. Johnson last this morning, but he'll need to be here.
He's on the way. She called me, he was in some traffic.
Okay,
but-
he's not late. He was listed as going last. And he is on, it's not a very short list, but the list for next Monday in front of Judge Emerson. As far as I can tell, 3 or 4 of the cases ahead of it are going, and so we wouldn't get close to Mr. Johnson, but, and then I don't know if you, Ms. Davis, were on the email from Ms. Gladden,
I was. I tried to call her too and email back.
like this case,
Yeah.
this
so,
case, please.
Yeah. So,
on-
yeah.
Oh, well. But there were pictures.
They were very, and they were,
Yep.
and screenshots. So
They looked legit.
They did. They did.
Okay.
Sorry for him. So.
Yep. So it sounds like Mr. Terry is ready. You want to do that since we've got the lawyers and all that, we can get rolling with that. Okay.
Mr. Terry's case is a Willingham case.
Oh, it's also a Willingham?
Yeah.
She's on her way, so we'll wait.
Yeah.
Okay.
And the Tyquil Solero on 2 of the cases. And Ms. Willingham is one of the cases.
Okay. Well, we'll still probably do, since we need Ms. Willingham, we'll do that one first because he's online rather than sitting in custody.
She just called me.
Yeah, she said because her sound wasn't working, she was walking over. It's funny, we could hear your voice, like, hello, hello?
Yeah, I just couldn't figure out why my sound wasn't working, but I could tell you guys could hear me, because I could see Ms. Davis saying it. I just couldn't figure out why. So I gave up.
Thought it was twice already.
Oh, okay, don't worry about it.
It's still doing weird stuff? Okay, we'll put in a ticket with court support. Yeah, she really chafes with that camera. Ms. Willingham, we're gonna do Jonathan Terry first. If you could get ready for that and come on up to the witness stand when you're ready. You coming up to the podium?
Yes.
You are, okay. All right, are you ready?
Yes.
Okay. Good morning, Ms. Rivers. Are you ready to take some things down? Ms. Rivers, are you able to hear us? She can hear us. Great. Okay. We are going to get started then. Mr. Terry, can you unmute, please? Are you able to hear? Great. You able to hear us?
Yes, sir. Yes, sir.
Okay. We're going to go on the record in your case, which is 25 SC 002 370. And Mr. Terry, Ms. Wood tells me you're prepared to enter a plea in your case. Is that correct?
Yes, sir. Correct.
Before we can get started, I need you to confirm on the record that you are comfortable appearing virtually rather than being here in open court. You all right with that?
Yes, sir. Correct.
You have a right as well to have Ms. Wood sitting right next to you so that you could ask her questions or share with her whatever you're thinking about this plea. But she is here and you are in a car somewhere, not here. Are you also okay proceeding with your lawyer not right by your side?
Yes, correct, sir.
Will you let me know if at any point you want to speak privately with Ms. Wood, because she could hop on a phone and have a private conversation with you if you need that?
Yes, sir.
Okay,
Oh,
sounds
right.
good. Well, Ms. Willingham is going to swear you in and then ask you a series of questions about your case and your rights. Please answer those truthfully, and please let me know if at any point you've got questions of your own, okay?
Yes, sir.
All right.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, correct.
You can put your hand down. Please state your true, correct, and legal name.
My name is Jonathan Alvin Terry.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
So you hesitated for a minute. That may have just been a lag in the connection. Are you thinking about something? Any
No,
reason?
the connection.
Okay, we're good. We'll keep going.
How old are you and how far have you gone in school?
I'm 32. I'm 32 years old, and I had dropped out in 11th grade, but I was in Penn Foster doing my high school diploma online classes before I got locked up.
So you got your diploma, or you were in the process of doing it?
And I was in the process, and now I'm still enrolled in it right now. Like I'm still doing that as well, like right now, because I had already paid what I had owed.
Okay.
Mm-hmm.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss the case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Have you reviewed the indictment in this case?
Yes,
Do you waive formal reading of the indictment?
we do.
Has your client been arrested on these charges?
Yes,
The state is unaware of any outstanding warrants related to these charges. Do you or your client know of any outstanding warrants that are related to these charges?
we do not.
Mr. Terry, do you understand that you are entering a plea to the following offense? Aggravated assault, which has a minimum of 3 years and a maximum of 20. And that count 2 of this indictment will be null pros.
Do you understand that, sir?
Yes, ma'am.
Okay. And no pros means dismissed.
Has your attorney do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years to serve
190 days.
190 days. You're required to have no violent contact with the victim, complete family violence intervention program, complete 60 hours of community service, seek and maintain gainful employment.
Yes, ma'am.
And are you aware that the court does not have to accept that recommendation, and the court can sentence you to the maximum sentence on each charge and can run those sentences consecutively or one after the other?
Yes, ma'am.
Do you understand that if you do not accept the court's sentence, you may withdraw your plea today?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to a revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, ma'am.
Do you further understand, because this is a family violence conviction, if you are found in possession of a firearm, you could be charged on the federal level?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office.
You going in and out, man.
What'd you say? Mr. Terry, what'd you say?
I can't hear it because
Oh.
it's going in and out. I couldn't hear it because it was going in and out.
Okay, can you hear us now?
Yes, sir. Yes,
Okay.
ma'am.
Are you anywhere near the
I
courthouse?
can hear. No, so I'm actually at work. I'm just sitting outside of work.
Okay, and work is not near the courthouse?
No, sir.
Okay, well, let's try to make this work. If you could start those rights again.
I will. Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation, even if sentenced pursuant to the First Offender Act?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charge of aggravated assault in indictment 25 SC 002370?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Your Honor, if this case were to proceed to trial, the state would expect to show that on October 7th, 2024, officers responded to 511 Welcome All Road, South Fulton, Georgia, in Fulton County. And upon arrival, officers met with Tierra Reed, who stated she had a domestic dispute with with her child's father, Jonathan Terry. Ms. Reed stated that Mr. Terry kicked in her apartment door and damaged the door frame and the wall, breaking the lock off of the door hinges. Ms. Reed stated that Mr. Terry threw a large rock at the speed of light, and that after multiple rocks were thrown at her at a fast pitch, a large rock hit her in the face, leaving a small knot by her eye. When this occurred, Ms. Reed grabbed her 9mm handgun and shot at him twice. One bullet went through her front wall and exited out through the neighbor's apartment wall. Another bullet was lodged into the wall of an occupied apartment, F16. And that resident stated he heard gunshots and that one of the bullets went through his living room wall and hit the wall towards the bedroom. The occupant of F16 stated that he was too scared to leave the apartment. Officers were able to see the bullet holes, but no shell casings were located. Mr. Reed declined EMS and medical attention. Mr. Terry was not on scene at the time of the officer's arrival. Mr. Terry had active warrants at that time for probation violations from another aggravated assault. Your Honor, I've had the opportunity to speak with Ms. Reed, and she stated that, I'm sorry, I'm going to switch back. Ms. Reed, I actually spoke with her on the 29th, and she stated that they are doing much better with co-parenting. She stated that her mom does a lot to help kind of keep both of them on track so that they don't have any other issues. She did believe that Mr. Terry could benefit from parenting classes and community service. I explained to her that parenting classes would be a part of family violence intervention program.
All right. So she understands that while Mr. Terry has done 6 months in custody, he would not be going back into custody.
Yes, Judge, I'm sorry. Yes, she did. We did talk about the offer in this case, and because she said that they are doing so much better with co-parenting, she felt that this was a fair and reasonable resolution.
Okay. Did it really say in the police report that he threw a rock at the speed of light?
Yes.
I like that. The Braves could use him. All right. So let me hear, please, from Ms. Gordon from pretrial about Mr. Terry's criminal history.
Good morning, Your Honor. The defendant has 11 arrest cycles beginning in 2010. Last arrest, June 25th of 2023 from Union City for battery family violence. That case was transferred to Superior Court November 25th of 2024 under 24 CR 007289F. Record also indicates a felony conviction in Fulton County in 2016, first-degree burglary, aggravated assault, family violence, first-degree arson, terroristic threats, and criminal damage to property in the second degree. 2017 felony conviction, Fulton County, aggravated assault and unauthorized possession of a weapon by an inmate, and a 2019 felony conviction from Tatnall County, willful obstruction of law enforcement officer. Nothing further to add, Your Honor.
All right. Thank you. Ms. Simpson, is Mr. Terry on probation now?
No, Judge. All of his cases expired in November of last year.
Okay. Thank you. Mr. Terry, what was going on in Tatnall County?
I was in prison at the time.
So that's something that came up while you were in custody.
Yes, sir.
Okay.
Exactly.
Got it. Ms. Wood?
Thank you, Judge. Mr. Terry is currently, as you know, sitting outside of his job. He works at a warehouse full-time. He does have a stable address. He's a lifelong resident of the area. He does share the 2-year-old child, as you've heard about. Judge, it's my understanding, and I'll let Mr. Terry add any facts that he wants to add for the court's understanding, but he was actually, I believe, at the home with permission earlier that day and left his cell phone. And then I don't know what happened in between the morning and the noon. But there is a Ring camera where he's knocking on the door and then goes in, and then you see the shots fired into the other apartment. So he has had some big feelings about the fact that she didn't get any charges for shooting into someone's apartment. But in any event, he's accepting responsibility. He understands that he's accepting responsibility and he's ready to move forward with his life. Judge, so we just ask that you accept the state's recommendation.
How would you describe the nature of the relationship between Mr. Terry and Ms. Reed now? And I don't mean adjectives like tumultuous, but structurally, they live together, they co-parent, they see each other only when exchanging the child. What is that setup?
I'll let him explain. I don't think they're still together in that sense.
Okay.
That's my understanding, but,
He disappeared.
oh no.
We'll have to wait till he rejoins. Oh, no, he's here. He's on, but he's coming
Hello?
back.
Hello?
Yeah, can you turn your video on? So, Mr. Terry, we can't see you. What happened? There you are.
Yes, I'm here.
What happened?
Not a bad connection.
Okay. So when did you drop off? What was the last thing you heard?
You had asked me about Tatnall County.
Okay. Then I asked Ms. Wood about how you and Ms. Reed are still connected. I know you have a child together. Tell me, do you guys live together? Are you dating? Or it's just, look, we've got this kid and we have to interact because of the kid?
Yeah, it's just about the kid right now. Like we came to an agreement. Like it's no longer, it's good co-parenting.
So do you live in the same place as Ms. Reed?
Yeah, I think she do stay with her mom. I don't know for sure. I don't be there like that. I just like call her mom and just talk to her mom just to see my child.
Okay, so you and Ms. Reed do not live together?
No, sir.
Okay.
Not at all.
All right. How long have you worked at this warehouse?
Since June, I say 5 months. Yeah, close to 5 months.
Okay. How many?
I got 2 jobs. I have a morning job and a night job.
What is your night job?
They call BSW. It's a meat packing warehouse job. In my morning job, it's a picking and packing job.
Why do you have 2 jobs?
Because I'm trying to get my own house, and get me like do my own thing instead of living with my sister. Cause I'm still living with my sister.
Okay, got it. Well, that's a good goal to have. Mr. Terry, do you have any questions about anything we talked about?
I mean, no, sir. I just want to get the case over with and just, do my little probation and just do my community service and classes, so I can just keep on the right track. Yeah, I
Okay.
do have a son, and I do want to be a great father, cause I ain't had no father. I promise you, I ain't had no father.
Is the child that you have with Ms. Reed your only child?
Yes, sir.
Boy or girl?
It's a boy,
Name?
Giovanni Altier. He got my last name.
You got your last name?
Yes,
Okay.
sir.
All right. Well, Mr. Terry, I find there's a factual basis for your plea. I understand that at most you were throwing rocks and at least Ms. Reed was shooting a gun at you. So it's a little bit of a strange situation, but here we are. I also find that your plea is knowing and voluntary. That means you've understood what we talked about and no one's forcing you to enter your plea. Do you agree with that?
Yes, sir.
I'm sentencing you pursuant to the Probation Options Management Act. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
And Ms. Willingham, can we sign for you?
Yes, Judge.
Mr. Terry, is it okay if we electronically sign your name to the indictment indicating your plea to count 1?
Yes, sir.
All right. Well, I'm going to follow, for the most part, the recommendation from the 2 sides. Your sentence as to count 1 is 5 years to serve 6 months with the balance probated, and you'll get credit for the time you have already spent in jail or prison. I don't know if you went down the road or if it was just at the jail, but either way, you'll get credit for all of that, which means you're on probation for 4.5 years. Special condition of probation number 1 is no violent contact with Ms. Reed. So you can be around her, you guys have a kid together, but no rocks, whether you throw them slowly or at the speed of light, none of that. You will need to complete a family violence intervention program. That's not just one class, that actually is a bunch of classes and it takes a bunch of weeks. But you'll need to do that, and you will need to enroll within the first 2 months of probation. So don't kick the can down the road. You will also need to get your GED. So that means getting back into whatever class you're doing or whatever program. So you get your diploma or equivalent, and you'll need to get back enrolled in that within the first 6 months of your probation. You'll have 60 hours of community service. You'll need to do all those during the first year of your probation. And I'm setting what we call a behavioral incentive date of October 4th, 2028. That's 3 years from now. If you've done everything you're supposed to do on probation, got your GED, finished these programs, and most importantly, haven't gotten arrested again for beating up a girlfriend, then probation can say, let's just close this out and let Mr. Terry do his own thing. Because you'll have shown us that that's exactly what you want to do. You're taking care of your kids, you'll have your own spot, all that kind of stuff. Any questions about, oh, and count 2 is dismissed. So the sentence is only as to count 1. Any questions about that sentence, Mr. Terry?
I don't have any questions, Your Honor.
Ms. Wood, anything else on behalf of Mr. Terry?
No, Judge, thank you.
Ms. Willingham, on behalf of the state?
No, Your Honor.
Ms. Simpson, what do you need to tell Mr. Terry about probation? He's an expert on probation, but he's been off it for a little bit, so he needs to get back involved.
Yes, Judge. So Ms. Wood was kind enough to provide me Mr. Terry's address and contact information. So Mr. Terry, your reporting date will be October the 9th at 9 a.m. You're going to report to the Atlanta office. That is 276 Memorial Drive. That is in Atlanta. And the zip code is 30303. Ms. Wood will be able to provide that address for you so that you would have it physically with you.
All right.
Thank you, Judge.
Thank you. All right, Mr. Terry, good luck. Go back to work.
All right. Thank you, sir.
Judge,
Oh, hold on, don't go yet.
did we do the permission to sign?
Yeah,
Oh, I missed that.
we did. You said yes.
Forgot it.
Yeah. All right, you're good to go.
All right.
So we have Astiero, Phillips, and Diggs. We can handle those in whatever order. If there are people online or in court or whatever, if you have a preference.
Diggs.
All right.
Yeah, Lord. Yeah, roll. You see?
The guy with the robe has a warrant?
Gibson got it.
Oh, what a matchup. Gibson and robe.
Something from one mother.
All right. Let's figure out what we're doing this morning with Mr. Diggs. Good morning, Mr. Diggs. I'm okay. How are you doing? I'm still okay. So Ms. Wood, this was identified as maybe a plea, maybe a motion for bond. We now have Ms. Nix, who's relieved that that camera doesn't work over there right now. What are you hoping we do?
Hoping we can do a bond motion.
Okay. I was hoping we would do a plea, but I guess that's not in the cards. You don't need to hope for a bond motion. Were you on notice that there'd be a bond motion? I know there's a victim here. It's a stalking
No,
case.
The victim is not here, Judge. The victim
No,
is
I'm
not
sorry.
here.
Not that the victim is here, but in this case, there is a
yes.
victim. And so I want to make sure you knew we'd be talking about bond so that you got Ms. Ray's input.
Judge, the victim, I was not on notice. I was on appropriate notice for a bond hearing. I was on appropriate notice for a bond hearing on October 7th.
Okay.
The victim is available on that day. She has already got it in her calendar. She has the Zoom link, and she
Okay.
is available on that day to do a bond hearing. That's in 4 days. So we are prepared to go forward on a bond hearing at that time.
So I'm not. I'll be in trial. And what we can do this morning is at a minimum hear from Ms. Wood and Mr. Diggs. And then what time was Ms. Ray going to be available? Was she going to be available 9 a.m. on, I don't know we have a bunch of calendars on the 7th. Was it
She
afternoon or morning?
put it, I think it was in the morning. I think she put it on her calendar for the morning. But I mean, we can work with your schedule we can do it over lunch break or whatever.
Well, no, my preference would be to do it right at 9. The way we're going to run next week is we'll start trial more like 9:20 because of all these calendars that were already set. People are going to be coming in who are on bond and I want to take attendance and that kind of thing. And then we'll shift to doing the trial. So we're trying to disrupt as little as possible. And that's why we tried to get Mr. Diggs in today. But it is important that I hear from Ms. Ray as well. So if you could make sure that she's available at 9. Ms. Wood, you don't need to be, you may be coming over anyway because of some of the calendars, but you could zoom in the same way that Ms. Ray is. I don't know about, we can bring Mr. Diggs over. We're bringing people over if that's your preference, but we can start the conversation now or just wait till Tuesday, however you want to do it.
I would like to start the conversation now, Judge. I thought I saw someone with the same last name as the alleged victim on Zoom, but I don't know if it's her or her mother.
No, I see, there is a Vivian Ray on, and there is also a Ms. Diggs.
That's my client's sister, Judge.
Okay. So Vonda Ray is our victim listed in the indictment. I'm not sure. There's a Ms. Ray on this call. Could you let me know if you're associated with Vonda Ray?
I don't believe that she is, Judge.
It's an interesting coincidence.
Yes. But Ray is a common name.
I'm sorry, Your Honor. This is Lisa Diggs, the sister. Vivian Ray is the mother of Vonda Ray.
Okay. Got it. Thank you, Ms. Diggs. I don't know if you can do any outreach to, or if you've got a victim advocate. It's peculiar that the mother of the victim's here and the victim isn't. So maybe there is a way to get Vonda Ray here.
Ms. Ray just had major surgery.
Okay.
So she's not available.
Okay. Well, let's press on either way in that I want to let Ms. Wood make her presentation. There may be things Mr. Diggs wants me to hear. His mom is on, or he has kin on. I'll hear from them. And I just won't close the books until I have a chance to hear from Vonda Ray. But as I said, if you've got a victim witness advocate who could reach out to Vivian Ray, it may be that I could hear from her today too, since we're all together. Let's get on the record. This is 25 SC 004840. It's State versus Jerry Diggs. Mr. Diggs is charged with aggravated stalking. And the allegation is that on Halloween of last year, Mr. Diggs did contact Vonda Ray, that's spelled W-R-A-Y, in violation of a temporary protective order. So a serious situation, as alleged, and it's just an allegation right now, but certainly something that would have been disturbing for Ms. Ray. But I also understand Mr. Diggs' situation right now is pretty complicated on the medical front. And so I'd like to hear from Ms. Wood about her thoughts and what's going on. Oh, and let me add one more thing to the record.
Judge, I'm sorry to interrupt you. That is actually an error in the indictment, and the state is actually going to do a re-indictment. In this case, that date is actually the day that the TPO was entered. The actual date is June 20th, 2025.
Okay, so much more recently.
Yes, sir.
All right. Yeah, that would be an error. Mr. Diggs is in no bond status. He was given a $15,000 bond for a count that wasn't indicted, but no bond for aggravated stalking. So I think that's the posture we're in. Ms. Wood, now that we're on the record, what do you want to share?
Thank you, Judge. So he has been in custody 100 days. My request of the court is just to switch that $15,000 bond over to the aggravated stalking charge. I will note for the court, he has a parole hold. So he has to deal with that. If he were in a bond, he would have to deal with that before he went anywhere, Judge.
What does that mean? I know those words, but where do you go for a parole? Like, where is a hearing on that?
They would come to him, Judge.
Thank you.
Tell me what that means, though. Like, they just like go into his cell at the jail and say, "Sit down. I have a court reporter."
So so he's on parole in Virginia. Because he lives here, he had ICOTS done to Georgia, and so we are supervising him for that case. Yes, the violation of a TPO order was considered as a parole violation, so he's possibly facing a parole revocation, which means someone, not all members, but someone from the parole board would come to see him and address it, and they would make the determination as to continue him on parole, or he would have to go back into state custody.
Got it. And it would be state custody in Georgia, or it would be state custody in Virginia?
I believe it would be state custody here because his parole case is here.
Okay. So Virginia wouldn't really be consulted, assuming Georgia was willing to manage all the parts of it, both the revocation and then the incarceration.
They would be notified, but we would be able to make the decision on if they decided to put him into custody. We will remain in custody because his residence is here.
Okay. How much time remains on that Virginia sentence?
It expires January 23rd of 26, so in a few months.
Okay. All right. Is there a expected time of a revocation hearing? Or, I mean, the hold says to me, hey, if you're done with him, Fulton County, then Mr. Diggs is going somewhere else. But he'd actually stay in the county jail until someone from the parole board could meet with him?
That is correct, Judge, because there isn't a specified facility. If he were in state custody, it would be a little different because they would just go to that facility into a private room. But yeah, it would be the same with him being in county custody. They would just bring him into a separate room and they would have an official hearing, but it would be held at the jail.
But I could give Mr. Diggs a $10 bond and he's not getting out because of this parole hold, and he will stay where he is until someone from Pardons and Paroles comes to meet with him and adjudicates the situation.
That is correct.
I'm sorry for the 60 questions. Do you have a sense of whether they, meaning Pardons and Parole, move faster if the only thing holding Mr. Diggs is their hold, or they're on it already and they're likely to come meet with him soon, whether he gets a bond or not?
It's kind of hard to make that type of determination based off of the availability of one of the board members.
Okay.
So it's really kind of hard to make that determination. I could make a phone call to find out if you needed a more closer idea.
Not yet, but I may. We're not resolving things today anyway, because it's important that I hear from Vonda Ray. But it may be a factor if what you learn is there's no movement on the parole side. If something else is holding Mr. Diggs, why would they spend time pursuing this, especially given that his sentence expires in a few months? Versus, no, I called and they have 30 days to do something about it, and that clock has already been running for 10 days or something. Those would be very different answers. But I appreciate this explanation. Let me go back to you, Ms. Wood.
So this case, while it was in the pre-indictment stage, the medical staff at the jail started contacting our pre-indictment attorney, basically saying, hey, he's an end-stage organ failure. He goes to dialysis 3 times a week. It's a over 4-hour process each time. The sheriff's office has to dedicate resources to take him to Greg and be there with him, and then back, of course. He's got some other health issues as well. I know while I was out, Miss Hammond, my investigator, was visiting with him on medical unit. There was an emergency. There's a port that was placed in his chest. It was actually supposed to be placed in his arm. That has still not been rectified, Judge. So he's going through it. He has a sister, like I said, that's on the Zoom call. He has a Locust Grove address now. I understand he's got a criminal history, but given the severity of his health issues, and the fact that the jail is blowing me up, asking why he's still in custody, and it's convenient they never asked the district attorney's office why he's still in the bond status when they go to the news and such, Judge. But in any event, I'm just asking for a reasonable bond on this case, so that Mr. Diggs can move on to his next location.
Okay, and that next location would be in Locust Grove. Ms. Diggs, is that accurate that Mr. Diggs your brother would be able to stay with you and that your household is in Locust Grove?
That is correct, Your Honor.
All right, thank you, and thank you for being on the call. Ms. Wood, how would you describe, if you're comfortable doing so, Mr. Diggs's connection to Vonda Ray? Why would she have a TPO? That's a different question. What was their connection?
I think at one point, Judge, it was a romantic relationship. Okay. Yes. So it was at one point, Judge, a romantic relationship.
All right, got it. Ms. Nix, what are your thoughts about how we strike a good balance here? And again, I will hear from Vonda Ray, and we need to very carefully weigh her concerns about her peace, safety, and security. But we also have a scenario where it sounds like it's pretty darn complicated for our sheriff and his team to manage Mr. Diggs, not because of his ill behavior, but because of his health condition. Which, to be clear, is not Vonda Ray's problem. That's not my point. But we've got a few things to weigh here.
Judge, I'll just start with the fact that I think that his health conditions have been going on for a while, and he has been continuing to harass Ms. Ray through his conditions. He's continuing to come by her apartment, leave things for her. I have currently 20 voicemails that he has left her, some of which are saying, hey, I left something for you. Why don't you call me back?
This is since he's been in jail?
No, the allegations.
Supporting the state's case?
Yes.
Okay.
I have, let's see. Right now I have 65 screenshots of text messages. The victim is sending me more. This harassment just has not stopped. And I have absolutely no belief that if the defendant is granted bond, that it will stop. And I believe that the only respite that Ms. Ray has had has been the last few months that the defendant has been in custody. And while I understand the sheriff's concerns, I don't think anyone else is looking out for Ms. Ray.
Okay. No, I hear you. And custody is not the province of young, healthy people only. There are complicated situations where custody is appropriate, even though that person may not be in good health. So I hear you on that front. How would you describe, based on your work on the case, the prior connection that Mr. Diggs and Ms. Ray had?
They were in a romantic relationship. I'm not sure who ended the relationship. I would guess that it was Miss Ray, based on the fact that the defendant continues to ask her to contact him and says that he still loves her and wants to, just begging her to call him.
Okay, I don't want you to get into lots of the substance, but there was some romantic relationship at some point. It ended, and very clearly, Ms. Ray wants it to stay ended and
Yes, ma'am.
be able
Yes,
to
sir.
go in her own direction.
And Judge, I'm texting with the victim, and actually she says that that she, even though she feels terrible after her surgery, she does feel like she can power through and would like to make her statement now.
Okay, well, then we can do it all at once. Is she with her mother? And so the Vivian Ray link is the one we're using, or is she going to hop on differently?
She's going to hop on different, Judge. She and her mother are not on good terms, I understand.
Okay.
If you will give me just a moment, I will see.
No, take your time. I appreciate Ms. Ray pivoting this way. While that's happening, Ms. Wood, is there anything more you want to add? I'll let you end after we've heard from Vonda Ray, but anything else from Mr. Diggs's side?
Only judge that I don't have discovery, so I can't fully respond to the allegations of mistakes on the record, but we do maintain our innocence in this case.
Judge,
Oh,
you-
this was on for plea and arraignment. Okay, I'm wondering, like, why don't you have discovery? That's not like Ms. Nix, but we don't even have a scheduling order. Can we do a waiver of arraignment today? Fantastic. And we'll get a scheduling order in place, and that will move this, and the indictment's very new. Okay. So you'll do a waiver, and we'll do a scheduling order, and then you'll get lots of text messages and voicemails.
I know that I got the Zoom link. Where is it? There it is.
Do you need the link or you have it?
I got it.
Okay.
I found it.
I was surprised too.
Because I have another Anthony Johnson.
I'm sure there are lots.
Yeah. Because I did. But yeah, he doesn't have any of it, because that was on probation. Yes.
She says she's on, Judge.
Is she a phone number? That's the only,
Is it a 757 number?
no, there's a 320.
Oh, she says one moment.
Just need to turn video on and we'll know. Hey, Ms. Ray, is that you? Good morning. We can't hear you. Nope. Still no audio from your end. Do you want to try dialing in? We can use this video and you can use something else for the audio.
Can you hear me okay now?
Yes, ma'am. Let me try this. All right. Can you hear us?
Yes.
Okay. I'm Judge McBurney. I appreciate you dialing in. I know that this was on your calendar for next week. I had a few things shift around and we tried to move, we did move Mr. Diggs's bond hearing to today. Ms. Nix told me that you've been through a few medical procedures and it's a complicated time for you, but I appreciate you making yourself available. I did explain that I wouldn't make any decision today if we couldn't hear from you until next week. I just wait to hear from you, but if you're comfortable talking with me today, I'd love to hear from you.
Okay, yes, sir. Can you still hear me okay?
Yes, ma'am, I certainly can. And let me tell you what we talked about so far. I heard from Mr. Diggs's lawyer about his medical situation. I learned about a parole hold he has, and that if he did make bond, how he would be staying in Locust Grove. I have no idea how far that is away from you. I don't want you to share your address. But I am interested in knowing how far away Locust Grove is from you. Most of all, Ms. Nix wanted me to hear from you about your thoughts about Bond and Mr. Diggs. Okay?
Yes, sir. It's approximately maybe 50 minutes to an hour from me.
Okay.
And would you like for me to begin?
Yes, please.
My name is Vonda Ray, and that's spelled VONDAWRAY. I'm opposed to bond because Mr. Diggs is a danger to me, my friends, my direct community, and the public. I've lived this nightmare and consistently feared for my life for over 2 years. I have made no contact, and I revoked all access to me. I was granted a 12-month protective order by Judge Amero on October 31st, 2024. However, Mr. Diggs has continued to stalk, threaten, and harass me by physically popping up at my residence via phone, text message, voice messages. He's created over 75 different spoof numbers, cyber stalking, and harassment from social media accounts. Mr. Diggs has caused me physical danger by choking me and threatening to kill me, stalking me at my home, at my pool, threatening to jump the fence to harm me and my neighbors when I was trying to enjoy leisure time. Emotional and mental danger by constantly stalking, threatening me, my financial career. He stole my debit card, made fraudulent purchases, obtained my social security number fraudulently, texting me that he would intentionally ruin my credit, putting me at risk for my career and my livelihood, all because I said no to his violence, actions, and abuse. I'm in constant fear for my life, not knowing when and where he will show up or contact me. I've been uprooted and had to leave my home and stay with friends just in case he comes to my home. I love to swim, but I haven't been back to my pool since July 2023 when he popped up there in fear of my life, not knowing when he's going to come. I love to host my friends at my home numerous times per month, but I stopped in 2023 because I fear I'm putting my guests in danger, not knowing when he'll pop up at my home. I must consistently check in with my friends and neighbors. I have security at work and also the Union Police Department patrolling my home doing welfare checks on me. I've suffered severe physical, emotional, and mental trauma at the distress in the hands of Mr. D. He told me in open court in Henry County Court numerous times It's evasive over the phone and via text. And if I ever called the cops on him, he would kill me because he has direct access to his sister's gun where he resides in the home. He has defamed me via my family and friends in an open court. He boasts and found humor in the protective stalking order, stating it's only a misdemeanor. He must be held accountable for his deliberate and intentional choice. He continues to break the law and violate my rights in a direct court order. I've taken every precaution legally because I'm fighting for my life and my safety. I've done everything I can. I've contacted the police. I've petitioned the court. I've asked his sister for help. I've called his federal probation officer on several occasions, asking him to beg him please to stop. I finally was granted the protective order, but he hasn't stopped and he won't stop until he kills me. I'm the victim in this case, and my safety and the public is in danger. Mr. Diggs' actions and violent criminal history is proof and evidence that he has no regard for the law, and he will stop at nothing to gain access or contact me, killing me and violating a protective order. I ask that you consider my safety and the safety of the public by denying bond. Thank you.
Ms. Ray, thank you for sharing that. I've got a couple questions. How long ago was it that you and Mr. Diggs were in a relationship? I'm just trying to understand the timeline. When would you say that started?
That started in January of 2023.
And when was it that you said you wanted it to end?
In June of 2023.
Okay, so about 6 months.
Yes, sir.
Okay. All right. Thank you very much. Ms. Nix, do you have any questions for Ms. Ray?
No, sir.
All right. Ms. Ray, you're welcome to turn the camera off. You're welcome also to stay on the call if you want to stay on the call.
Okay, thank you.
You're very welcome. Good luck with your recovery.
Thank you.
All right. Ms. Nix, anything more you want to add?
Yes, sir. I wanted to point out something that I think may have been confused earlier. The defendant was originally arrested for both aggravated stalking and violation of a protection order. The state chose to go forward just on the aggravated stalking. So this isn't a situation where he was arrested for a misdemeanor and then we upgraded. He was arrested for both.
I saw that, and the Judge Petty set no bond for the ag stalking, set a bond for the violation of the protective order, and when the charging decision came down, your office went forward with the aggravated stalking.
Yes, sir. And the no bond decision was made based on the fact that the defendant is a danger to the victim.
Okay. Ms. Wood, anything more on behalf of Mr. Diggs?
I just stand on my argument, and I would ask that if the court decides to deny my motion, that the court would consider putting in the order a basis for that, so that I can share it with the medical team.
Sure. Okay. I will do that. What I'm going to do, Mr. Diggs, is get a little more information from Ms. Simpson. That's the probation person we heard from a little bit earlier, who was helping me understand the parole hold. I'm going to follow up with her, not so much about the facts and circumstances of your Virginia case, but to understand more when might parole do something about the violation they think has occurred. I have one more question that I want to have on the record in case either side wants to respond to it. And that's for Ms. Gordon with pretrial. I'm curious to know about Mr. Diggs's criminal history. I could only see the one arrest here for these charges. Obviously, there's something out of Virginia. And so I'd like to better understand Mr. Diggs's criminal history.
Your Honor, the record indicates the defendant has 54 arrest cycles beginning in 1996 with multi-state interaction from the states of Virginia, New York, and Delaware. Last arrest, July 27th of 2020 from Hampton, Virginia. Assault on a law enforcement officer, judge, Department of Corrections personnel, fire or emergency person. That charge resulted in a misdemeanor conviction for assault with unsupervised probation. Record also indicates 6 felony convictions outside the 10-year period, 2 from Delaware, 1 from New York, and 1 from Virginia, which includes the 2 U.S. probations that the defendant was on. Nothing further, Your Honor.
All right, thank you so much. All right, I appreciate again, Ms. Nix, you getting Ms. Ray on before the scheduled time of next week. We are not going to need to reconvene next week because Ms. Ray was able to make it. I will get an order out, either granting bond with whatever conditions I think are appropriate, or denying it, but I'll do a new order so that there is something that both sides have. And Ms. Wood, if you will do that waiver of arraignment, as soon as you are able, we will get a scheduling order in place so we can make sure this moves along. All right, thank you, everyone.
That's my only case, Judge. May I be excused?
Yes, ma'am.
Lacey, I'll go ahead and request discovery be sent to you.
Judge, I think there might be, Mr. Gordon might be here for the Phillips case. And if that's so, we can Mr. Astor there, just very briefly back.
Great. All right, Victor Gordon.
Morning.
Good morning, sir. How are you?
Going well, so.
All right. Are we able to bring Mr. Phillips out while Ms. Wood is talking to Mr. Astiero, or that's tricky? Sure.
Judge, while they're talking, do I have time to make that phone call?
Yes, please.
So he would probably, he decided when he comes out.
What's he going to be signing?
Oh, wait, we're
Oh,
going to go ahead and do
If
the
you're available to handle it today.
no, please, since you're here, I appreciate you coming in off cycle.
All right, Judge. I don't mind proceeding.
All right. Can we bring him out, or?
Please.
Okay.
2 cases.
Thank you.
You know, Mr. Phillips has a second case. Does he not have bond on the second
He
case?
does have a bond on there, and I believe it was reinstated. I just entered on it, I believe it last night.
You did, yeah. No, it's all, it got transferred to us from non-complex. Thanks, non-complex. So we ought to do an arraignment, a waiver on both, so they can move together.
So you still want him to enter his plea on the record, though? No?
I'll ask, we'll walk through it.
Okay.
All right, let's get on the record. This is Choice Phillips, and he is here on 25 SC 004740, and we're going to address 25 SC 005484 as well. It's a case that was very, very recently transferred here from non-complex because of the older case. Mr. Phillips, I'm Judge McBurney. Nice to meet you. You are here with your lawyer, Mr. Gordon. We have Ms. Davis here from the state, and we're going to talk about both your cases in terms of waiver of arraignment, and then we're going to talk about bond in connection with the case ending in 740, because you've got a bond already in the other case. So first, Mr. Gordon, is Mr. Phillips prepared to waive arraignment and enter not guilty pleas through your completion of the waiver of arraignment forms in the two cases?
Yes, sir.
Great. If you will, when we're done talking, fill out those two waivers. You can leave them with Deputy Gordon. We'll get them filed. That will trigger a scheduling order from my team. That'll give the state a deadline to get you discovery, so you don't need to worry about motions in 10 days from arraignment. There's actually a motions deadline in the scheduling order that you'll get that is several weeks after the deadline that the state has to get you all the discovery. And we'll move forward that way. Mr. Phillips' waiver of arraignment is simply Mr. Gordon saying we're entering a not guilty plea, and his agreement that he wants to participate in discovery, the exchange of information, so that he can get with you about what the state has in these two cases. So let's talk about bond in the case ending in 740, which is an aggravated assault and possession of firearm charge arising from an alleged incident on December 30th of 2023, and a young lady named Tiffany Hills. I'm ready.
Okay, thank you, Judge. Mr. Phillips is he's 45 years old, originally from New Jersey, northern New Jersey, and moved to the Atlanta metro area in 2009. Just going to put that out there and to get ahead of it. He does have a colorful criminal history. Starting in New Jersey, he has 3 convictions from over 20 years ago, as well as he has multiple convictions in West Virginia for possession of a firearm by a convicted felon. As far as what we have this case here, which is pending, and then we have the other case that's within their court that's still pending. And being that there's no conviction in that, he's still perceived innocent until proven guilty on those charges. I don't believe he's a substantial flight risk. He does have one failure to appear in 2018 from Coweta County. And then this other case, which is the possession of a firearm by convicted felon that's within this court, I believe that he had a failure to appear on that as well. But if the court is inclined, the defendant is ready, willing, and enabled and amenable to if that risk is a concern for the court, to wear some type of ankle monitor in that regard. As far as him being a danger to the community, a danger to the victim. This incident allegedly occurred in December 30th of 2023. The victim was which is almost 2 years ago. The victim was extremely intoxicated, so her account of events more than likely was affected by it. In fact, neither her injuries nor her behavior for an entire year afterwards reasonably relate back to what she alleges occurred that night. She maintained an ongoing, continued relationship with the defendant up until January of 2025. And then they, at some point, even moved in with each other during that time for a couple of months prior to their breakup. No additional incidents of violence were ever reported to law enforcement after this case, until the victim hadn't even responded to the investigator in this case until January of 2025 after they broke up. It's potentially motivated by revenge because he was at that time moved out and was with another woman who he's currently engaged to. So I say that to say I don't believe that he's a significant risk to her safety or anything of that nature. But of course, within some added conditions that he stay away from her while he's on bond. If that is an additional concern while he's out on bond. That's all. We just ask that the court set a reasonable bond in this case for this matter. And that's all I have for right now.
All right. Let me look at a couple things here. Okay. Ms. Davis.
Yes, Judge. So we've had the opportunity to speak with a member of our office, but with the victim, Ms. Hills. She was, as my understanding, may have jumped on the Zoom call. It was shared with her yesterday, so she may not be on the call. I'm not sure if she has any words to share at this time, but I know for certain that she wants no contact whatsoever with the defendant. She indicated that there may be indirect third-party contact by the defendant's mother towards her. And so we just want to make it clear that nobody, family members, cousins, fiance should be reaching out or contacting Ms. Hills. The nature of the allegations are concerning for the state. We do believe that he is a danger to the community and at risk of committing a felony. Mr. Phillips has several felony convictions, most of which involve a possessing a firearm. This, of course, also alleges a firearm, his second case, a firearm. That's deeply troubling, knowing that those are items that are prohibited from him. Whatever happened that day, that may be something else, but he shouldn't be around any guns, period. But he still manages to do so. And so our position of the state, if the court is inclined to set a bond, that it be a high bond to make sure that the defendant does not commit any further violence.
Can I add something that I forgot?
You can in a minute.
Okay, thank you.
I'm just trying to get the chronology straight here because
It's strange.
it is strange. So the situation with Ms. Hills was in December of 23. And police were called to the scene then, December 30th, 23, Zone 4 request support of ag assault unit. They talked with Ms. Hills, et cetera. And Mr.
Your Honor, I
Phillips.
am here as well.
Oh, all right. Well, thank you for being here, Ms. Hills. We didn't mean to speak as if you weren't. I think Ms. Davis just couldn't tell from the list here if you were here. Is there something that you would like to add to what Ms. Davis said about your concerns, your thoughts about bond, anything like that?
Yes. So actually after the event happened in 2023 in December, the police were called and I actually have an email string. I was trying to contact them. I emailed different entities and it was hard to get any help back and forth. We didn't talk for a couple months after that. Of course, he came apologizing. I have a recording of him saying exactly what happened and how he's sorry and this and that. And it was, I was dumb to the fact of going back and forth. It wasn't an ongoing relationship and we never lived together. We were back and forth. I was actually, to be honest, in a whole nother relationship. So yeah, I was wrong to being with him off and on. And actually it did happen again. And there's another police report where he actually choked me almost to death. And my son had to call the police. And he fled from that. And each time I kind of just let it go. But the last strike, it was not off of jealousy or anything. I'm actually happy that he went away. We were actually out one night and he started acting. It's always when he gets drunk, he got belligerent. He started acting crazy in the place. And I looked at the police and I said, hey, I need to leave by myself. He got upset. He wanted to go with me. And I just told him to leave and I was done. That's the last time I heard from him. He went to my house by himself. I wasn't there that night. He stole most of my clothes. He took a lot of my possessions, and I never heard from him again. His mother actually tried to put a TPO on me in July of this year randomly and say that I've been stalking her. I think they're trying to scare me into dropping this, and I haven't been in contact with her. I have no reason to contact her. So when the court date came up for the TPO last month, she actually didn't show up and it was dropped. Besides for that, yeah, I am afraid of him. I'm afraid to the point where I'm sorry, I'm shaking now. I just feel like he told me at one point that if he ever went to jail before he went to jail, that he would kill me. So, and I read in paperwork, like from his previous, one of his previous cases, that he can't control his impulses, it said. And I am worried about that. I have children, I'm a single mother. I'm scared that if he gets out, he may come to try to hurt me so he doesn't have to go to jail. I don't know. So
All right. Well, I appreciate Ms. Hills, you plugging in. It's always important to hear directly from someone who is involved. Ms. Davis does what she can with the pieces of paper she's got in front of her, but it's always helpful to hear from someone who was there at the time and experienced what you just described that you experienced. So over the last 6 months, say, you've had no contact from Mr. Phillips?
no, sir, I have not.
Okay, but somehow his mom and you are interacting? I'm
Yeah,
not
we didn't interact. After he left that night from January, he went to my house and stole my stuff. Me and his mom were pretty okay. So I contacted her and I said, hey, he stole my pots and pans, my clothes from my home and all that stuff. And she was like, oh, well, I'm gonna try to find it. So we talked about that one time. And we haven't had contact since then. And then in July, randomly, I get a TPO order to my home saying that I've been stalking her and she just wants me to leave her alone. So I actually gathered all my phone records and everything, and I went down and I was telling them like, no, I believe this is a tactic to get her son out of jail. Please don't accept this. So the day of court, actually last month when I went, I guess she had already went when she saw that I responded and did what is it, a motion. I filed a motion that she dropped it and she never showed up.
Okay. All right. Well, Ms. Hills, I appreciate you sharing all that. Anything else you want to add?
No, sir, that's it. Thank you.
Well, thank you for being here on short notice. I'm gonna take you off the screen, but you're welcome to stay on the call.
Yes, sir.
Ms. Davis, anything else from the state?
No, Your Honor.
Okay. Mr. Gordon, I promised I'd come back to you. You're the movement, so you get the last word. And what I don't want to do is have a back and forth. I know what you said this situation was about is different from what Ms. Hills did, but ultimately that's for a fact finder if we get to trial or whatnot. But I do want you to add anything more you think I ought to hear.
Well, I never talked about, that he does have a significant other that also lives in the area, his mom, who's in the courtroom, his uncle and his 3 children, who also live in the Atlanta metro area. He is a business owner, a barber, and a tattoo artist, and he has been for over 20 years. So therefore, he does have substantial ties to the community.
Okay, couple follow-ups on that. You said business owner. What is it he owns?
A barbershop.
Barbershop. Meaning there's like a brick and mortar building where I could go and get my haircut.
Well, I don't know if that's there now. Is it still there? Well, since he's been a country, he says it's still there.
Okay, but I mean, back in the day, if we rewound 9 months, there's actually, it might not say choice cuts, but I mean, it's his spot. It's not that he had a booth somewhere, but he had his own barbershop.
It was his.
Okay. And if Mr. Phillips gets out, where does he stay? And I don't need the street address now. I'll need it because I'll put it in the bond order, but you can get that. Is it with mom? Is it with girlfriend? Is with whom? Okay, and what city is that in?
Atlanta, Georgia.
Atlanta.
In Atlanta? Okay. And Mr. Phillips, do you have kids?
Yes, I do, sir.
How many kids?
3,
Ages?
26, 23, and 19.
Okay, I guess technically they are your children, but they are not kids, they are grown up. Great, and what do they do now?
My son is a tattoo artist. My daughter's in Eastern Michigan in college, and my other daughter's in college as well.
Okay, good for them. All right, Mr. Gordon, you'll do those waiver of arraignments. I'm gonna take this bond request under advisement. I'm gonna look at the bond that was reinstated in the other case. And it does look like, what I was really hunting for was, well, is there a revocation situation here? But there's not, meaning bond revocation. This conduct involving Ms. Hills was first chronologically December 23. The next case, and to your point, these are allegations and allegations only, May 24. So that conduct is after this situation. But Mr. Phillips didn't even have a bond in this case yet because it hadn't culminated in an arrest or anything. He got a bond. Mr. Phillips, got a bond in the other case and then got arrested for this. And that may have been why his bond went away for a little bit, but it was reinstated by a judge, as you pointed out. So there is an active, valid bond for the May 24 situation. And there's a repeated no bond. There have been several denials of bond for this case. And here you are now as counsel of record for Mr. Phillips. And I will get a bond order out shortly. And I'll also get scheduling orders out.
All right, thank you so
Okay.
much, sir.
Judge, my apologies. I was doing phone calls, so I don't know if it was mentioned. Mr. Phillips has a probation warrant in Henry County.
It was not mentioned. That's helpful to know. I did see, if I go back here to his notice of aggravation, there's a gun case out of Henry County from 2018. Is that the probation?
That's the failure to appear.
Let's see. Yes, Judge.
Okay. And Henry County would like to see Mr. Phillips to talk about that.
That is correct, Judge.
He says that it's not for that charge. It was for the tinted windows. I haven't verified that.
It's a misdemeanor violation, but it's for a felony case.
Oh, meaning the allegation in the petition from Henry County is a misdemeanor violation, probably tinted windows, but it relates back to the probation Mr. Phillips is on for possession of a firearm by a felon out of Henry County.
That is correct, Judge.
Okay, got it. Okay, a lot of moving parts for you, Mr. Phillips. No one did mention that. I appreciate you sharing that, Ms. Simpson. If I deny bond or set a bond you can't make, we can also work on getting you to Henry County to try to sort that out so you can see if everything can work out at once. But we'll work through it. You got a good lawyer moving your cases forward. Mr. Gordon, anything else on behalf of Mr. Phillips?
Nothing further.
Ms. Davis, on behalf of the state?
No, Your Honor.
Okay, thank you. Nice meeting you, Mr. Phillips.
Once I finish with these waivers and speak with them, can I be excused?
Yes, sir.
Thank you.
Thank you for being here off schedule.
No problem.
Ms. Hills, Ms. Davis or someone from the DA's office will be in touch with you after I enter the order, letting you know what's happening next, okay?
Okay, thank you.
You're welcome. Ms. Wood, are you ready with Astiero?
Yes, sir.
How do you pronounce his first name?
Yeah.
Okay.
I was too.
Ms. Willingham, are you ready?
It is me and Ms. Davis.
Oh, that's right. I forgot. You got the,
And then I'll just add in my facts.
okay. But the center of gravity is with Ms. Davis.
She's still on.
Yeah, sure.
You can. And because I always tell her name.
Okay.
So we sending him back? Okay. Okay. Two jurors, and I'll, get this on the record with, Ms. Fagan on Monday have already said, like, what, you can't have picked me, the Coca-Cola lady, and then the Alaska Airlines, flight attendant, which is totally unexpected, nothing she told us, but she's gonna show up with her mom on Monday. And then the other woman's gonna show up ready to rumble, but we'll see where all that goes. All right?
I'll send that to probation for you.
Yep. There you go. Thanks. You ready?
Yeah.
All right.
For sure.
Ms. Wood, are you ready?
We're ready, Judge.
All right, let's get on the record. We are working through three cases today. Is it a plea to all three?
Yes, and it's non-negotiated.
Okay. 25 SC 001 703, 25 SC 002 679, and 25 SC 002 682. All of these cases belong to Mr., is it pronounced Astiero?
Yes, sir.
Mr. Astiero, who is here in court with his lawyer, Ms. Wood. Ms. Davis is handling two of the cases for the state. Ms. Willingham is handling the third. Mr. Astiero, in a moment, Ms. Davis is going to put you under oath, then ask you a bunch of questions about your rights. Tell me a little bit about two of your cases. Ms. Willingham will tell me about the third. Then I'll hear from Ms. Wood and you if there's anything you want to add. Ultimately, at the end of the discussion, after I hear from both sides, I'll be imposing a sentence. Because this is your final plea date, if the sentence that I impose is more severe than what Ms. Wood asks for, you'll have a chance to talk with her about, I don't like it, but it's better than going to trial, or I really don't like it. And then you can say, no, thank you. It's that easy. And you'll go back to where you are. We'll move your cases to a trial calendar. And in the next month or so, we'll get you in here for a trial. So you'll have a chance to process it if what I think is the right sentence is different from what Ms. Wood does. You're not locked into it. Now, if I agree with her or I go below that, you're locked into it. Does that make sense?
Yes, sir.
Okay. Ms. Davis, when you're ready.
Please raise your right hand. Do you swear or affirm the testimony that you will give in this matter before the court shall be the whole truth and nothing but the truth?
Yes.
Okay, you can put your hand down. Please state your true, correct, and legal name.
Spell it out or just say it?
Say and spell, because we're all dying to know how to say it, but you got to spell it.
Taquil Asiero. Capital T, lowercase a, lowercase q, lowercase u, lowercase y, lowercase l, lowercase e. Capital A, lowercase s, lowercase t, lowercase I, lowercase l, lowercase e, lowercase r, lowercase o.
Thank you.
Welcome.
At this time, are you taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 32 and I've gone to acquire my GED.
As in you have it or you hope to get it?
No, I have it.
Okay.
I acquired it in 2011.
Okay. Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes.
Do you understand that you're charged with the following offenses? An indictment 25 SC 001703, theft by shoplifting, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon. An indictment 25 SC 002682, possession of a firearm by a convicted felon. And in 25 SC 002679, aggravated assault, possession of a firearm during the commission of a felony, and theft by taking.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Attorney Wood, about all the facts and circumstances known to you in all 3 indictments, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with their services?
Yes.
Attorney Wood, do you waive formal reading of all 3 indictments and any and all defects therein for the purposes of this plea?
We do.
Mr. Astillero,
Yes.
do you remember having been arrested on these charges?
Yes, ma'am.
Your Honor, the state's unaware of any outstanding warrants related to all of these indictments. Attorney Wood, are you aware of any outstanding warrants related to these matters?
I'm not.
Attorney Willingham, are you aware of any outstanding warrants related to these matters?
I'm not.
Thank you.
Thanks for checking with her too.
Mr. Astillero, has your attorney advised you the minimum and maximum sentence for each charge to which you are pleading to today?
Yes, ma'am.
Okay, so I'm going to start with indictment 25 SC 001703, theft by shoplifting. It is a minimum of 1 year, maximum of 10, based on the amount. Possession of a firearm during the commission of a felony, it is 5 years consecutive. For possession of a firearm by a convicted felon, that is a 1 to 10 year sentence. An indictment 25 SC 002682, it is also possession of a firearm by a convicted felon, that is 1 to 10 years. An indictment 25 SC 002679, aggravated assault, a minimum of 1 year, max of 20. Possession of a firearm during the commission of a felony, 5 years consecutive. And theft by taking, based on the amount, I believe it's 2 years to 20 years. And Attorney Willingham, you can correct me if I'm wrong.
That is correct.
Do you understand that?
Yes, ma'am.
Do you understand that if your guilty plea is a blind plea, also called a non-negotiated plea, the state will still make a recommendation to the court?
Yes, ma'am.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence as recommended by the state, up to the maximum sentence on each charge?
Yes, ma'am.
Do you understand that if you enter yes, do you understand that if you enter this non-negotiated plea, because it is your final plea, you do have the right to withdraw it if you do not accept
Yes,
it?
ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including federal courts?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'd be guilty of another felony, which may carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? I'm going to go over 9 and then ask, do you understand, okay?
Yes, ma'am.
The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have only 4 years from today for the felony charges to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
How do you plead to the charges in indictment 25 SC 001703, theft by shoplifting, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon?
Guilty.
How do you plead in indictment 25 SC 002682, possession of a firearm by a convicted felon?
Okay, guilty.
How do you plead in indictment 25 SC 002679, aggravated assault, possession of a firearm during the commission of a felony, and theft by taking?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Your Honor, the state believes the evidence would show at trial in indictment 25 SC 0017Z03 that on January 17, 2025, officers with the Atlanta Police Department were called out to 3340 Peachtree Street in Atlanta, Georgia, in Fulton County in regards to a theft by shoplifting. At that time, officers met with the loss prevention officer from the Saks Fifth Avenue. They reported that there was an individual who took a Givenchy crossbody bag. That individual was later determined to be Mr. Tyquil Astillero. He put the crossbody bag on his body, walked up a couple levels of the store, and then attempted to exit all checkpoints without paying for the bag. The loss prevention officer did waive or use a metal detector to check to see if Mr. Astillero stole any additional items. At that time, they discovered that he had a gray in color firearm in his waistband. In indictment 25 SC 002682, we believe the evidence would show that on March 3rd, 2025, officers with the Atlanta Police Department were called out to 3393 Peachtree Road in Atlanta, Georgia, in Fulton County. In regards to allegation of identifying the defendant, the officers were flagged down by loss prevention officers from Louis Vuitton. And they indicated that the defendant, Mr. Astillero, had taken previously about $4,000 worth of merchandise before from their location and from Phipps Plaza. Also, an individual with Montclair identified the individual as having previously stolen some items. Officers made contact with him. They ran his name. There was a warrant. And so he was taken into custody. When they did a search incident to arrest, they obtained another firearm.
It says a shotgun in the indictment.
Yes.
This was like in his pocket or it was in his car?
I believe it was on his person, is my understanding.
Okay, well, we'll hear more about it when we get to the defense side. Either way, this is all weaving together. It's more high-end shoplifting. But it sounds like with this indictment ending in 682, it wasn't that Louis Vuitton's people saw Mr. Astillero doing something then and there. They said, this is a guy who in the past has done things,
Yes.
call the police. Unsurprisingly, there's a warrant for Mr. Astillero. And in the process of taking him into custody, this shotgun is found.
Correct.
Okay. It wasn't a new shoplifting.
No, Your Honor. And
Okay.
they did show, it's my understanding, I don't believe we had those videos, but they did show the officers' video footage of him.
Okay.
Yes.
And then
Ms. Willingham.
we've got our February 28th sandwiched between, however you say it, Givenchy and Louis Vuitton. We've got a whole lot of jewelry.
Jewelry?
Yeah, it took over $25,000 worth of jewelry from your victim.
Oh, well.
I hope that's where we're getting. That's what it says in the indictment.
Yes,
That's correct.
yes, Judge, I'm sorry.
Protect
I always
elite
forget
watch.
the theft parts that are on here, but yes,
Okay.
that is correct. It's gonna be red.
Okay.
In indictment 25 SC 002679, the state would expect to show that on February 28th, 2025, officers responded to 1110 Hammond Drive, apartment 382, Sandy Springs in Fulton County. And upon arrival, officers spoke to a neighbor who stated that Destiny Concepcion Woods ran to his apartment for help after she was assaulted by her boyfriend, so he called 911. Officers then spoke with Destiny, who stated that she and her live-in boyfriend, Tyquil, got into an argument that turned physical. Destiny stated that when she woke up, she accidentally turned on the TV, waking up Tyquil and causing an argument. Destiny then grabbed the firearm to avoid Tyquil using it on her. A struggle ensued over the gun. He retrieved the firearm and pointed it at Destiny, stating he would kill her. Destiny tried to run for the door, but he blocked her and another struggle ensued. She got away and crawled out a window. Destiny then went to the neighbor and called 911 since she had been locked out. When officers arrived, they tried to make contact with the defendant, but he appeared but it appeared that he had already left the scene. Destiny climbed back in through a window to let the officers in. When they came inside, Destiny noticed thousands of dollars worth of her jewelry missing. She stated she got most of her pieces appraised and showed the officers the paperwork for several watches, rings, and necklaces worth well over $25,000. Officers obtained warrants for the defendant, and he was later arrested on March 3rd, 2025. And Your Honor, I have attempted to contact Miss Destiny multiple times. It does look like someone spoke with her just before the plea and arraignment. We did a victim locate last week, and then shortly thereafter, Ms. Woods also provided me with contact information, but she has not called us back. At the time we spoke with her, she was fine with the bond amount that was set, and she was fine with him getting out on bond. No one had an opportunity to speak with her about what she wanted to see overall happen.
Okay. So we don't know if she got the jewelry back, or at least you don't know whether she got the jewelry back.
Correct, Judge.
Okay. Okay. Thank you. Ms. Gordon, can you share criminal history information, please, about Mr. Astiero?
The defendant has 21 arrest cycles beginning in 2012 with multi-state interaction from the states of Pennsylvania and New Jersey. Last arrest, January 17th of this year from Atlanta. Felony theft by shoplifting, possession of a firearm or knife during commission. That is case that ends in, that's on your calendar this morning, that ends in 703. Record also indicates there appears to be an open case out of Trenton, New Jersey with an arrest date of May 16th of 2023. Aggravated assault, strangle, domestic violence, 2 counts, terroristic threats, criminal restraint, criminal mischief, damage to property, possession of a weapon for unlawful purposes, and unlawful possession of a weapon. In addition, there's a probation from Philadelphia, Pennsylvania, firearm carried without a license, and robbery, 3 years probation, November 5th of 2022. 2 additional felony convictions out of Pennsylvania, 2017 retail theft, 2018 retail theft. Nothing further to add, Your Honor.
Thank you so much. I appreciate that. Ms. Wood. Oh, wait, I didn't get a recommendation from the state, so I don't know what I'm comparing. I know they're not going to be the same.
No, Your Honor, we are recommending for the indictment 1703 that Mr. Astiero be sentenced to 6 years to serve 1 year, balance on probation, for him to complete an anti-theft course, provide proof of his GED, if not, obtain it, 60 hours community service, forfeit all guns, and for him to stay away from Saks Fifth Avenue, Montclair, Phipps Plaza.
It'll be, yeah, that whole Lenox Phipps area.
Yeah, you gotta stay away from that, Louis Vuitton. And then for the case ending in 2682, it is just a possession of a firearm by a convicted felony to be the same sentence.
All right. Got it. And Ms. Willingham, as to the 679?
Yes, Judge. As to the 679, the state's overall recommendation would be 8 years to serve 1 year with the balance probated. No violent contact, complete family violence intervention program, no weapons, seek and maintain gainful employment, and seek and complete 60 hours of community service. The breakdown of that would be 3 years to serve 1 year as to count 1, as to count 2, 5 years consecutive, and then as to count 3, 3 years to serve 1 year.
All right. Thank you. Ms. Wood.
Thank you, Judge. And I'll just let you know, the only thing that we are not in agreement on is the time to serve. Mr. Astiero has been in custody since March the 4th, so he's got 214 days under his belt. I think that's right at 7 months almost. So we would be asking for a total of 8 years probation to serve 7 months, and then the balance probated. He's originally from Pennsylvania. He had only recently moved to the Atlanta area. He does have a stable address to return to. I shared that with Ms. Simpson. It is here in Fulton County.
Is it the Hammond Drive address or a different address?
That's it. It's
Okay.
our understanding. So my investigator, Ms. Hammonds, was able to get in touch with Destiny She is no longer in the state. She wants nothing to do with him or the case.
Okay, so their spot is still available to him. She is not.
Correct.
Okay.
That's our understanding. And that's what she shared with us, that she's just ready to be done.
Okay.
And so he has somewhere to go. Like I said, he was working at a cleaning company in Pennsylvania before he moved here, and then he got caught up in all of these cases. So he will need to get a job once he is released, but that is our request of the court judge.
All right, Mr. Astillero, anything you want to add?
Yes, I'm just hoping that I'm giving what Ms. Woods has asked. And I don't know if she mentioned to you, but Destiny had filed a waiver of prosecution to have those charges dismissed because what she said in the case was it wasn't true. But I'm here today to get this over with, you know what I'm saying? I've been here, Mr. McBurney, for 7 months, going through all kind of stuff in the jail. I'm not from here. I'm ready to get my life started. I made some mistakes, and I'm hoping that you can understand that I am trying to do better. I had a rough, life. I had a rough upbringing. I did a lot, but I'm just hoping that you give me a chance. That's it.
Okay. Did you know Ms. Concepcion from Pennsylvania or New Jersey, or you met her here?
No, back home.
Did you two move down here together?
Yes.
Okay. Do you have any kids?
No.
Okay. But you two are done, it sounds like. Okay. And she's back either in Pennsylvania or New Jersey or wherever.
Ms. Wood said, she said she's back there.
Okay. But you two moved down here together.
Yes.
It sounds like some of what you got mixed up with here, the shoplifting, the high-end shoplifting, et cetera, was sort of similar to maybe what was going on in Pennsylvania or New Jersey. Is that sort of your thing? I just understanding how it was your hustle.
Yes.
Okay. Why do you think the apartment is still there? I mean, physically it's still there. No one tore it down, but you haven't been there for 7 months. And if she's gone, what makes you think someone else doesn't live there?
It was paid up for a year.
Oh.
The lease was up for a year, so it would be up. We moved there February 3rd, so it would be up February 3rd of this year.
Okay. And you paid a whole year in advance?
Hmm?
Okay. All right. What else do you have in Atlanta that connects you to Atlanta?
Well, I was doing music here. I had a job here.
What kind of work? Because the cleaning work I thought was in Pennsylvania.
So here at the complex that I was staying at, which is called the Airbell Perimeter, I was actually doing maintenance there too.
Okay.
So I was able to acquire a job there doing maintenance with my experience from doing cleaning back at home. So, I mean, I know that if I go back there, I have no problem getting my job back. And I left Philadelphia to like basically start over here.
Yeah.
But I got mixed up in some stuff.
Okay. All right. Well, Mr. Astillero, I find there is a factual basis for your pleas, in particular, the ones involving the shoplifting. I mean, that's what you were doing. I appreciate that maybe you and Ms. Concepcion had an argument and she described it one way, you remember it a different way. She's said, I don't want to prosecute. That doesn't control what the state does. But it does sound like there may have been a gun in the mix and you are way past being able to have a gun around. I also find that your pleas are knowing and voluntary. Knowing means you've understood things. You seem very aware of what's going on. You're very well spoken. I hope that you can chart a different way forward and apply your smarts to something other than ripping off the high-end malls. And voluntary just means no one's forcing you to enter these pleas. I understand why you're standing here. You're hoping to get out soon. I'm sentencing you pursuant to the Probation Options Management Act. Ms. Wood, can someone in my office sign all 3 indictments for you?
Yes, Judge.
Ms. Davis and Ms. Willingham, can we sign your respective indictments?
Yes, Judge.
Yes, Your Honor.
And Mr. Astillero, is it all right if we electronically sign your name to the 3 cases indicating your pleas?
Yes.
All right. So I can break down these sentences across all the counts. I don't want to do that and have poor Ms. Nelson, who is listening in, do all that until you and Ms. Wood have a conversation. I want you to know that I'm going to follow the state's recommendation. I actually am is a little lower than I thought the state would come in at, given that this is sort of an extension of what was going on in Pennsylvania and New Jersey. I'm glad to hear no one got hurt. You bringing a gun into a shoplifting situation could get messy, not because you come in, it's not shoplifting if you pull out a gun, that's robbery. But you having the gun and law enforcement and you make a wrong move and then all of a sudden an officer has a gun out and you're hurt, or someone else is hurt, it's just real dangerous. And I think that the year is more than appropriate. I won't go above that, but I'm not going to go below that. But that's different than what Ms. Wood asked for. And so like I promised you at the beginning, you're going to have a chance to talk with Ms. Wood to say, you know what, let's just go to trial. I think I could beat this one with Destiny. I don't know how it's going to work on the other ones. You have a very distinctive appearance. And my guess is that the loss prevention folks will say, oh, I know the dude. I know when he walks in. But that's your call. I want you and Ms. Wood to talk about it. If the answer is you want to go forward, it's going to follow same kind of conditions. I'm not going to vary from that all that much. It's more than what you asked for. It has the consequence of your apartment, because if you don't get paroled, it may be that you're in custody when your lease is up, all that kind of stuff. So it's not a simple decision. I want you two to talk about it and let me know. Okay?
Good.
All right.
Thank you, Judge.
And when we're done with this, whatever the outcome is, I think the last thing for this morning is Mr. Johnson? Okay. All right, not yet. We've got to finish this, gentleman.
Fourth case.
We have a fourth case? He has a fourth case.
Yes.
Mr. Johnson
And
does.
Ms. Wood knows about it. I just wanted to give it to you because I don't.
Is it another carjacking?
No.
Oh. Okay, what's it about?
Taking a car.
Okay. Is it indicted?
Okay. Yes.
Okay.
She's aware of it. It was just recently.
Got it. Is it with us?
Let me see.
You can tell me the case number. I'll look it up.
We'll do it at the same time then. 25 SC 005829.
Yep, it's here.
Yep.
Got non-complex like that transferred. They're getting good at that. That by taking. All right, I'll add that to the list.
Judge, in regards to Mr. Diggs, it's going to require quite a few more phone calls.
Don't make any more. I appreciate that. You don't need to work it any further than you did.
Are you sure?
Yes, ma'am, I am.
All right.
Thank you. I appreciate you if it was an easy answer, you make one phone call and they say, hey, you know what, it's going to be in the next 30 days. That's good for me to know. But I learned enough in hearing from pretrial services and whatnot to do what I need to do with that one. So you don't need to track that one. It'd be good in the future to know how that process works. I've never had someone on a parole hold, but you don't need to sweat this one.
Okay. Yeah, so apparently Virginia was contacted in regards to the violation. So that's the extra phone calls.
Got it. Okay. All right. Well, I appreciate that update, but we're good with him.
You're welcome.
All right, Ms. Wood, have you and Mr. Estiero had time to talk?
Yes, Judge. So he had a question and I advised him, but I'll let you correct me if I'm wrong. My understanding, it is up to the custodian to determine where the remainder of the sentence would be served. Meaning that I don't believe this court can guarantee that he would stay at Rice Street. So I have advised him of that. I think he wants to accept the sentence, but I just wanted to put that out there.
Sure. It's a fair question, Mr. Astiero. And a couple things would factor into that. One, is this a parolable situation or not? And it is, you're parole eligible. And two, it would be how much is left. And you've already done more than 7 months. And so there's not a lot of time left in that equation. And so it may well be that the sheriff's office and the Department of Corrections talk and they look at it and they say, look, he should stay where he is. That's not my call. You're sort of right at the edge. If you had done 11 months of the 12, you would be finishing up right where you are. If you had done 1 month of the 12, I know you would be going down to Jackson. You are closer to you might stay where you are, which has risks and benefits as you've experienced life there. But I don't want, and I know Ms. Wood didn't give you that certainty. I don't want to give you that certainty either of, I know how it will play out. But if I were weighing it, I say it probably trends more towards, they're going to look at the math and say, keep him here. And then, because it doesn't make a whole lot of sense to transport you and they process you and they're figuring out diagnostically where you're going to go and like, oh, parole, and he's out. So I can't give you more certainty than that. Having heard that answer, do you want to go forward with your plea?
Yes.
Okay. Then let me get all that on the record. Get your piece of paper here. So in 25 SC 001 703, your sentence as to count 1 is going to be 3 years to serve 1 year. Count 2 has to be 5 years and it has to run consecutive to count 1. I'll probate that. And then count 3 will be 3 years to serve 1 year, and that'll run concurrently with count 1. Total sentence, 8 years to serve 1 year, balance on probation. Special conditions of probation are stay away from the Lenox Mall, Phipps Plaza area. 2, you'll forfeit whatever was seized from you. I don't know if they got your Smith & Wesson then, but if they did, that's gone now. 3 will be get your GED. You've already done that, so it'll just be documenting that you got your GED. 4 is 60 hours of community service. That's going to be in each case. That doesn't mean 180 hours of community service. It's one set of 60 hours. And then 5, you're going to need to take an anti-theft course. The 60 hours of community service you need to do in your first year of probation. In the next case, this would be the Destiny Concepcion Woods case, 25 SC 002 679. Your sentence as to count 1 is 3 years to serve 1, balance on probation. Count 2 has to be consecutive, has to be 5 years. That'll be consecutive to count 1. And then count 3 is 3 years to serve 1, and that's concurrent with count 1. That sentence will run at the same time as your sentence in 703. Special conditions, number 1, no violent contact with Ms. Concepcion Woods. If she reaches out, that's fine. You guys can talk, whatever. It doesn't sound like she will, but it's not a forbidden contact thing. You'll complete a family violence intervention program. That's a series of courses. You'll need to enroll in that within the first 3 months of your probation. And again, 60 hours of community service. And finally, in 25 SC 002 682, that is 8 years to serve 1 year with the balance on probation. No one ever told me about the shotgun and where it was.
That's a defect in the indictment that we waived, Judge.
Okay, it wasn't a shotgun,
It was a handgun.
but not a Smith & Wesson?
Yeah.
Another Smith & Wesson? That's your kind of gun. Okay. All right, but not a shotgun, just a Smith and Wesson. All right. Anyway, 8 to serve 1, balance probated. Thank you for waiving the defect. And then the conditions of probation there, you forfeit the Smith and Wesson that was seized from you. Stay away from Lenox Mall, Phipps Plaza, 60 hours community service, and prove up that you got your GED. And that is it. They all run concurrently with each other. You get credit for the time you've served. And I will set a behavioral incentive date of October 4th, 2028. That's 3 years from now. If you have figured out a way to move forward without lifting fancy stuff from fancy stores, and probation said, the guy's been fine, he's been working, staying out of trouble, then this can all be closed out, which is great. That's a burden off your back. But that's on you and no one else. If you keep goofing around like this, then not only will you probably have your probation revoked, but they're not going to be interested in ending it early. Any questions about any of that?
No.
Ms. Simpson, can you please give Mr. Astiero his reporting instructions?
Yes, Judge. So you will be reporting to the Atlanta office within 48 hours of your release. That office is located at 276 Memorial Drive. That's in Atlanta, and the zip code is 30303. Okay?
Yes, ma'am.
Nothing further, Judge.
All right, thank you. Mr. Astiero, you seem to have a good head on your shoulders. I understand life has been way more complicated for you than it has been for me. So I don't say, hey, start making right choices, but you got good wiring in there. I hope you are able to find a way when you're done with this one to navigate differently. Not easy, but you're getting to be an age where you got to be getting tired of some of what you've been going through. So it doesn't mean forever you're doing maintenance at an apartment complex. Own an apartment complex someday, but start out with a job and see what you can do and resist that temptation to roll the way you were rolling. We'll see what happens.
Yes, sir.
All right, good luck.
All right, thank you. All right, so thank you.
And Judge, that concludes my business. May I be excused?
Yes, ma'am.
Well, I'll be back if I can.
Yes, we've got 2 o'clock with Mr. LaScala.
Yes.
Excellent.
Deputy Gordon's gonna make.
Mr. Gordon, you're still here. Everything all right? Yeah. Oh, okay. Okay. We've got Mr. Johnson. We're gonna take a quick break, just give everyone 5 minutes. And I now understand Mr. Johnson has 4 cases, not 3 cases.
Yes, Judge.
Okay. All right. And Mr. Davis has been on the Zoom for a while now, so he's ready to go. This is a non-negotiated plea?
Yes.
Is it super non-negotiated or just kind of non-negotiated?
We're not as far apart as we once were.
Okay. All right. I will approach it with an open mind, given the charges.
We'll be making an adjustment on some of the charges.
Okay. Excellent. Well, I will be back. In just a few minutes, and we'll get rolling. Are we ready with Mr. Johnson?
Yes, we are, Judge. Thank you.
Johnson, can you come on up here, please? Ms. Rivers, you ready?
Yes, I am.
Great, we can hear you now. Excellent. Happy Friday.
Happy Friday, Judge. Switch computers.
Okay. We are going to get on the record in Mr. Johnson's cases. He is actually on the two trial calendars. Our trial calendar here that is kind of underway, and then he's on the consolidated calendar as well with Judge Emerson. Three of the cases are. There's a brand new case that just came in from non-complex. It's my understanding, Ms. Wood, that the goal this morning, hopefully all this morning, is to resolve all four cases.
Yes, that's correct, Judge.
Okay. Mr. Johnson, are you ready to go forward?
Yes, Your Honor.
Okay. You've watched a couple pleas now. Ms. Davis, in a moment, is going to put you under oath and ask you some questions about your cases and about your rights. You need to answer them as best you can. If at any point someone says something that you don't understand or confuses you, will you let me know?
Yes, Your Honor.
Okay. I'll try to explain it, or Ms. Wood may explain it, but we'll try to help you figure out what's going on. Then I will hear from your lawyer. I'll hear from you. If there's something you want to add, I may hear from Mr. Davis from the Next Level Boys Academy. Ultimately, we're going to come up with, if I accept your pleas, a sentence in your cases. All right?
Yes, Your Honor.
Okay. Your final plea rights are still preserved. And what that means is Ms. Wood may ask for a sentence that's different than what Ms. Davis asked for. If I give you a sentence that is more than what Ms. Wood asked for, just make up a number. She says you should be on probation for 5 years. And I say, no, it was so many cars. This was scary. There was a gun. I think it should be 10 years. 10 is more than 5. You two will be able to talk about it. And you may say, well, I don't like it, but I'll take it. Or you may say, you know what? I know I could go to trial soon, so I'd rather go to trial and see what a jury does than accept the sentence that you gave me, Judge. And I'll be fine with that. That'll be your choice to make, okay?
Yes, Your Honor.
All right. Ms. Davis.
Please raise your right hand. Do you swear or affirm that the testimony you will give in this matter before the court will be the whole truth and nothing but the truth?
Yes.
Please state your true, correct, and legal name for the record.
Anthony Rodney Johnson.
Are you at this time under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
Yes, I do take medication.
What do you take medicine for?
To keep myself calm and stable.
Okay. Do you know what the medicine's called?
No, sir.
How often do you take it?
Twice. Every 2 months.
Okay. It's not every day.
No, sir.
It's only once every 2 months?
Yes, sir.
Is it a shot?
Yes, sir.
Okay. When did you last get the shot?
I got to take another shot October 10th. That's my next shot.
Oh, it's coming up.
Yes.
Okay. Because it's been so long since you got a shot, are you feeling okay?
Yes, I'm a little antsy, but I'm good though.
Well, you're in court. You could be nervous. That's all right. But you feel like you're understanding what we're talking about.
Yes, Your Honor.
For how long in your life have you been getting this shot every couple months?
Since I had this incident with the cars and stuff, and I was seeking help. I went to a psych ward and stuff, and I got diagnosed with this. So
okay,
it helps.
So how old are you now?
25.
So when you were 20, for example, you were not getting this shot?
No, sir.
Okay, it was only after all this stuff came up, which was a few years ago, but it all came up. Yeah. That's when then you got this medical assistance.
Yes, Your Honor.
Okay. Are there any bad side effects to the shot?
I had problems at my job because it was causing me to move slow and my like bones were tight. I mean, my muscles were stiffening up and stuff like that. But other than that, no.
Okay. All right. Ms. Davis.
How old are you and how far have you gone in school?
I'm 25. I went my sophomore year in college.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you're charged with the following offenses? And Judge, just so it cannot be as confusing, I'm gonna do the indictments in order that they occurred. And if that makes sense.
Okay, you can do them in whatever order you want, and you can just use the last three digits.
Okay.
Ms., that's enough in the record for us to link them because they all have a unique last three digits.
Understood. And I'll just say, I'm starting now. Okay, so starting with 872, you are charged with hijacking a motor vehicle. The state is going to reduce that from first degree to the second degree, and possession of a firearm during the commission of a felony.
What is the difference legally between first degree and second degree?
Whether the weapon was was it pointed in their direction, and then also if he was able to obtain the vehicle.
So second degree, you don't even get the car?
You can.
But you just-
It can be attempt to.
Okay, you just aren't pointing a gun at someone to get it.
Correct. That's my understanding.
I'm not doubting you. I didn't know there were degrees. You don't even need to look it up. I just was curious.
Yeah, it's just without their consent from their immediate presence or attempts to. And indictment, last three digits, 873. That is also hijacking a motor vehicle in the first degree. The state is moving to amend that to the second degree, and possession of a firearm during the commission of a felony. For indictment 829, it is a theft by taking. And for 24 SC case, it is hijacking in the second degree, fleeing or attempted to elude, that is a misdemeanor, and possession of a firearm during the commission of a felony. Do you understand that you're charged with all of those offenses and those indictments?
Yes, ma'am.
Do you understand that do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Attorney Wood, about all the facts and circumstances known to you regarding the charges and the indictments, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Attorney Wood, do you waive formal reading of the indictments and any and all defects therein for the purposes of this plea?
We do.
Mr. Johnson, do you remember having been arrested on these charges?
Yes, ma'am.
Your Honor, the state's unaware of any outstanding warrants related to these cases. Attorney Wood, are you aware of any outstanding warrants related to these matters?
I'm not.
Mr. Johnson, has your attorney advised you of the minimum and maximum sentence for each charge to which you are pleading to today?
Yes, ma'am.
Okay. For hijacking in the second degree, it is a 1 to 10 year maximum. For possession of a firearm during the commission of a felony, that's 5 years consecutive, and that's for 872 as well as 873 because they're the same charges. In 829, theft by taking, it is a one to 10 year sentence based on the value of the vehicle. And in the 24 SC case, it's a 1 to 10 year sentence for the hijacking. Fleeing and attempting to elude is 12 months maximum, and firearm during the commission of felony is 5 years consecutive.
Yes, ma'am.
Do you understand that you are entering a blind plea, also known as a non-negotiated plea, and the state will still make a recommendation to the court?
Yes, ma'am.
Do you understand the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state and up to the maximum sentence on each charge?
Yes, ma'am.
Do you understand, as the judge explained, if you do not agree with the sentence, you have the right to withdraw your plea?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to the revocation for the balance of that sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including federal courts?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And that is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you'd be guilty of another felony, and that can carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? I'm going to go over 9 and then ask, do you understand, okay?
Okay.
The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal the convicted of these charges after a trial.
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have only 4 years from today for the felony charges and 12 months from today for the misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
How do you plead to the charges and indictment last 3872 to hijacking a motor vehicle in the second degree and possession of a firearm during the commission of a felony?
Guilty.
How do you plead to 873 hijacking in the second degree and possession of a firearm during the commission of a felony?
Guilty.
How do you plead to theft by taking in indictment 829?
Guilty.
How do you plead in the 24 SC case, hijacking in the second degree, fleeing or attempting to elude, and possession of a firearm during the commission of a felony?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Your Honor, the state believes the evidence would show in 872 that on December the 10th, 2023, officers with the Union City Police Department responded to 5851 Buffington Road in Fulton County, which was a Chevron gas station, in response to a theft. There they met with the victim, Mr. James Burton, who advised that while he was at the gas pump, he was approached by the defendant, who was later identified as Anthony Johnson. I did actually speak with this victim. He indicated that the gun was not pointed at him. It was actually pointed at the defendant. And he said that it was used maybe kind of to prevent other people from seeing the gun, but he didn't say that the gun was pointed at him.
Not meaning Mr. Johnson walked toward him with the gun to his head, just like, you can see I've got a gun,
Yes,
but I'm not pointing it at you.
correct.
It was brandished.
Brandished. Yes,
Okay.
Judge. The victim still had his key in his pocket. He did provide the defendant with a car key, but that car key was to a Camaro. This was a Dodge Charger. The defendant gets inside the vehicle. Obviously, he's not able to drive away or start the car up. The victim leaves and exits and goes to another location to get help. The defendant exits the vehicle and walks away and attempts to obtain another vehicle in the area. With regard to 873, this also occurred on December 10, 2023. Earlier that day, officers were dispatched and met with the victim, Mr. Ray Washington, who reported a theft of his vehicle. His vehicle was a Rivian. vehicle. He stated about 4:30 that day, he was at the Shell gas station at 3875 Flat Shows Road in Fulton County, Georgia, where the defendant later identified as Anthony Johnson, told him to give him the vehicle. That individual was described as a tall black male, 180 pounds. The victim's vehicle had a GPS tracking unit on it, and so the victim was able to track the vehicle to 5750 Buffington Road, which is Legacy Ridge Apartments. This apartment complex is right across the street from the Chevron in Mr. Burton's case. The victim was able to recover his vehicle. There was no damage to the vehicle. His personal items, including like a backpack, was still inside the vehicle, and he was able to successfully drive the vehicle away that day. There was no fingerprinting done because he took possession of the vehicle on the scene. In 829, which is a theft by taking, on January 30th, 2024, so about a month later, officers were dispatched to 3805 Flat Shows Road in Union City in Fulton County, Georgia. There, an individual pulled into the BP gas station. They left their vehicle unattended. The defendant, identified as Anthony Johnson, got into the vehicle and drove the vehicle away. There was no contact with the victim. And that victim being, sorry, let's see, Taj McBride. And then the 24 SC in indicted case, on February 12th, 2024, just a couple weeks later, officers with the South Fulton Police Department were dispatched to 6000 Fieldwood Road in South Fulton, Georgia, in Fulton County, in response to a vehicle theft. There they met with Mr. Robert Jackson, who reported his company vehicle, a Ford Escape, being taken. He was sitting inside the vehicle where he said he was approached by the defendant. The defendant asked him about a job, were they hiring, which was Allied Universal. The defendant, identified as Anthony Johnson, then brandished his weapon. Again, the victim indicated that he did not point the weapon at him, but brandished the weapon and said, "I'm going to need this car." And so the defendant then took, once he brandished his weapon, the victim got out of the vehicle and let the defendant take the vehicle. The defendant was arrested inside the vehicle. So they did recover all of the vehicles.
How did the Malibu, that 829, so we're now January of 24, BP gas station and Mr. McBride's Malibu. This was a slider situation, slid in, drove off. Did that car get recovered?
I'm not certain if that car was recovered, Judge. I did reach out to all of the victims before this plea. Our office off and on has had contact with some of the victims. We've done victim locates for some of the victims. The only one I was able to personally speak to was the individual with the Charger.
Okay, whose car never went anywhere because he was smooth enough to give him the wrong car key.
Correct.
Press it.
And so all these were in a short period of time. I mean, really 65, 75 day time frame.
Right.
Okay. The state made a recommendation for a negotiated plea. This is now non-negotiated. And so the state is, of course, going to ask for a little bit more jail time. Ms. Wood has kindly provided mitigating information about the defendant. And while we are sympathetic and understanding of some of the things that may have been going on with the defendant, all of these incidents, with the exception of the theft by taking, involved a weapon. And these could have gone in a very different direction. And so the state is making a recommendation of 15 years to serve 5 of those in custody. The balance of that on probation, that Mr. Johnson complete an anti-theft course, he has his high school diploma, that he complete a job skills or job training course, forfeit all firearms and any access that he has to them, and to stay away from all the incident locations, which I will provide to the litigation manager, to have no contact with any of the victims, which he should not. It just seemed like happenstance that he did make contact with these victims.
Okay, thank you. And it sounds like in terms of restitution, it would only possibly be the Malibu, but you haven't been able to determine the fate of that car.
Correct.
Because the Rivian was found with all its belongings. He didn't get anywhere with the Charger, and the Ford Escape got recovered. Okay. Ms. Gordon, can you share any criminal history information you have, please?
Your Honor, the defendant has 2 arrest cycles beginning in 2019 with multi-state interaction from the state of South Carolina. Last arrest, February 12th, 2024, Fulton County. Misdemeanor fleeing, no disposition, hijacking a motor vehicle that was not presented to the grand jury October 7th of 2024, and felony theft by taking, no disposition. Nothing further to add, Your Honor.
Can you repeat? You said only 2 cycles?
That's right. We're showing one cycle. We're showing one cycle out of South Carolina and one cycle out of Georgia.
Got it. Okay. That the Georgia part fits because that would have been the 963, and that's when Mr. Johnson was finally arrested in connection with these carjackings. Okay. Thank you so much. Ms. Wood.
Thank you, Judge. Bear with me because I feel a little bit like Ms. Rockwell. I've got a lot to tell the court today. So first and foremost, he was actually booked in twice, and I think I sent this to Ms. Nelson, but I will. He was arrested the day after the December 10th incident. So he served 46 days from December the 11th, 2023 until January 25th, 2024. I believe he was released on bond, and then he was booked back in on February the 12th, the day of the 24 SC case. It's my belief, my opinion, the only reason he was actually released on June 6th of that year is because the cases were dismissed at the preliminary hearing. So I'm sharing that with the court because I firmly believe that he would have been left in no bond status there and would have banked much more time.
No doubt.
So it's, he served over, I think it's 162 days or something like that on these cases. Judge, from the surveillance video of the 2872 case, it's very clear that Mr. Johnson is suffering from some sort of episode. It's almost as if he's in a trance. From the gas station surveillance, he does walk up in a trance, almost like a zombie, and checks a car, it's locked, and then he just kind of wanders over to the pump where the charger is. And that happens. And then of course the car doesn't go anywhere. And then he just calmly gets out of the car and continues walking. And so the police officers even note in one of the other cases, they comment on his bizarre behavior and the way he's acting off. I was able to obtain medical records from the jail from his time there, which also includes incident reports. The officers there also comment on bizarre behavior. They note things that are typical of someone who's suffering from mental health episodes, Judge. I will share with the court, he was, from what I can tell, he had a mental health evaluation in 2023 at the jail. They did, determine he had a diagnosis. He's got a couple of diagnoses, actually, schizophrenia, mood disorder, anxiety disorder. There's some manic issues going on. However, for better or for worse, he was not able to continue with the treatment they were recommending because of the release date in early of last year. But his parents were very concerned, so they did get him plugged in with treatment on the outside. I'm going to let his mom, if she wants to share with the court, I believe there's more than just the injection that Mr. Johnson told the court about. I have a list of at least 3 other medications that he is supposed to be taking more than every 2 months. So risperidone, the usuals, Depakote, trazodone, Judge. And so, of course, as you know, I like to share that with the court, not to excuse or justify, but just as to mitigate and to let the court know. And as you can tell, Mr. Johnson is not like most people that stand before you. He doesn't have much of a record at all. He graduated as the salutatorian of his high school class. He had an academic scholarship to a college in South Carolina. That's where he was, I believe, when he was arrested, that for whatever that was. His family did not realize that there was something going on until he went to college. And I'll let his mom share, but I believe it's my understanding she thought that it was perhaps behavior that was exhibiting itself. Maybe he wanted to be back home or was missing home, something of that nature. And so then, of course, it literally was not until all of these situations happened that they realized, hey, there's something else going on here. I shared some character letters with the court and the state. A number of people wrote letters on Mr. Johnson's behalf, Judge. Like I said, most of my clients don't have a number of family members here like Mr. Johnson does, so he's very fortunate to have that support. He was also accepted, as you know, into Next Level Boys Academy. I have Mr. Davis joining us to speak on his behalf for that. Judge, he is 25. He's at the very last end of that age range for Next Level. He lives with his family. He's currently gainfully employed. He works at a consignment shop. No one was harmed. I truly don't believe that he was stealing cars to commit other crimes or to sell them or do any nefarious acts, Judge. I really do, in my heart, believe that he was suffering from an episode. I know that doesn't excuse it. I understand that this could be a whole different situation if the gun had fired or if a driver had fired on him. You know, we see this all the time. And so I'm just standing here before the court, very humbly asking the court to see that even though this is 4 cases and it looks terrible on paper, it's really, there's more to it. And so I'm just asking the court to consider a sentence of 15 years on probation to serve what he has done. I've spoken to him about weekends in custody. I think we could make that work with his job. And then I hope Mr. Davis would also work with us on his next level requirements as well. And I'm also, my last ditch effort, judges, I know we don't do this much in here, but finally, if the judge doesn't think any of that's appropriate, I would ask for this to be like a back-ended sentence that is conditioned on his successful completion of Next Level Boys Academy.
Okay.
That's all I have.
I do want to hear from Mr. Johnson's mother, if she's comfortable talking about things. And maybe she can address this, but I'm going to start with you. The part that makes me a little concerned about the support network is that Mr. Johnson gets arrested as a result of the December carjackings, goes to jail for a couple months, and then gets out and is right back at it. And that's not me saying, what's up with you, Mr. Johnson? Because what's up with Mr. Johnson is that he had late onset mental illness, and he did phenomenally well age 1 through 18. But it's not uncommon for things to not manifest until the brain is done growing and stretching and whatnot. And so that part I get, but I worry, why is something going to be different now? Because if ever there was going to be a signal, it was your son got arrested for carjacking twice, spent a bunch of time in jail, and then the response was such that he was then able to again have a gun and again be taking cars. And so I need to be thinking about ensuring that that doesn't happen again, for his safety and the safety of everyone else involved, because you're exactly right. Any one of these could have been, oh, sure, I've got my keys in the glove box, hold on. And in the glove box is a Glock, and then Mr. Johnson's dead. Or someone who's walking by because everyone's a bad aim. Fortunately, that's not what we're talking about, but that's the risk factor that this conduct brings to bear. And so I need to understand why after the first cycle, there wasn't everything that I see now, which is medication, support, he's working. I don't follow it.
Understood, Judge, and that's fair, absolutely. I will note he has not had any other run-ins with the law since this February 12th, 2024 case. I don't know if that's a product of the fact that he is plugged in with his medication. His mother is helping him stay on track with that. He's living with his family. I do know, and I'm not sure, I probably have the timeline wrong. There was an incident where he was actually at a MARTA bus stop and was assaulted and pistol whipped. And I don't know where that falls in this. I'll let them share, but I don't know. Perhaps he was in the midst of a manic episode and was like, oh, I can't go to the bus stop, so I'm going to steal a car. And obviously that's not okay. But again, he, like I said, on the body camera, it's very clear that he is not firing on all cylinders at the time of these incidents.
So not just for the ones back in December, but also the January, February ones?
Yes.
Okay. One more question for you. And then I know his mother she's been raising her hand, so she can come up to the microphone in a minute. In all your interactions with Mr. Johnson, it has been post-medication. Have you felt like you've been able to communicate with him and you don't have concerns about Mr. Johnson's ability to understand what we're working through today?
I don't judge, and I'm glad you brought that up because I forgot to share this with the court. As you know, sometimes I have a hard time tracking my clients down. They change phone numbers and they don't respond, and then they show up at court and they don't know what's happening. He's the exact opposite. He has been probably one of the most proactive clients I've ever had. He sends me emails all the time, wanting to just check in and see how things going. Early on so when I first got this case, it was Miss Dilligard. And at that time, it was like only 1 or 2 indicted cases. The other 2 were still floating about. And we had mentioned doing, because we weren't sure that the other 2 were coming down the pipeline. So we had thought about behavioral health treatment court. And so he was very plugged into that. He even went on his own to look at resources for other programs. I've had meetings with him in my office with him and his mother, separately with him and then with them together. And I'm fully confident he's good to go now, Judge.
Okay. And BHTC was in the end not something because the state was vehemently opposed, or BHTC said, look, it's guns and carjacking and we get it that there's a mental health component, but we can't touch this.
I think BHCC was scared away. They haven't heard me ramble as I am here today about why, even though it's 4 cases, it's not as bad. They were the number of cases is what deterred them.
Understood. And they need to be careful with that filter for the program as well. Let's hear from, I don't want to say Ms. Johnson if it's not Ms. Johnson, but Mom. If you could come up, and you will be at the table where Deputy Gordon is standing. If you would sit right there, please, and make sure you talk into the microphone so Ms. Rivers, the court reporter, can hear you.
Okay, no problem.
Good. It's now officially afternoon. Good afternoon.
Good afternoon, Judge.
State your name, so that's in the record, and then share with me what you want to share.
My name is Delane Johnson. I'm Anthony Johnson's mother. So I wanted to address why, the in-between time, why he was arrested again. So he's an adult now. So
Yes.
I was trying to get help for him the entire time, like from the time he got back from school, because he started acting weird. And so like I noticed it, like I'm his mom. There was even one incident when I was literally chasing him down the street, like beating on him, like, what is wrong with you? I had no idea. You don't think your child is losing their mind, especially when they've been perfect like their whole life. So at that time, once he got back home and we noticed that he was acting very erratic, that's when I started trying to get help for him. He wasn't volunteering at the time to get help at that time. We just didn't know what was going on. I was like, well, let's get him some counseling or something like that. So then so in the in-between time, he got arrested. And I'm like, why are you stealing cars? Like, what's going on? You know what I'm saying? So we got him home.
Did he have his own car?
No, not at that time.
Did he tell you, hey, I need transportation?
No, I had a car and I let him use my car all the time.
Okay.
My mom has had a car. My boyfriend, we all, because he's so trustworthy, he could just, we don't even put stuff, you know what I mean? Like he had access to all of our people.
Okay. So that was the sound, like stealing cars. You don't need a
Yeah,
car.
like what's
That's
wrong with
weird.
you? Like, so then after the first arrest, he came home and then he got accosted at the bus stop. I think he was trying to get a job or something. I'm not sure where he was going, but he got accosted at the bus stop. We're not sure why. I don't want to speculate on that. And then after that day, I thought he had gotten shot or something. It was so bad. My mom has her phone. She can show you a picture of how he looked that day. And so we went to Grady. I begged Grady to keep him. I begged them to keep him. They would not keep him because they said they can only keep him there if he was a threat to, if he said he was going to commit suicide. And so of course they took me away from him and spoke with him privately. They had a counselor come and speak with him. And he told the counselor that he wouldn't commit suicide because he believes he will go to hell if he committed suicide. So he would never do that. So that counted that out. They wouldn't. And he's an adult, so I couldn't get him on my Medicaid or anything like that. So I started reaching out to people at church. I was reaching out to anybody that we could to get help. And in the in-between time, that's when he was arrested again
Okay.
for the carjacking.
But you eventually got help. How'd you do that?
Okay, so I eventually found when he got out the second time, at this point now, I'm 24/7 monitoring him. Like we're up 24 because he can't sleep, I can't sleep. We had the alarm on the door all the time, like every time, even the baby. If he opens the door, we're all rushing to the door, like, where are you going? What are you doing? Like, what's up? Because we know something's wrong. It's like he couldn't help it. You know what I mean? And so I'm sorry. So we had all that set up, and then finally I was able to after just calling 911 to the house to help us. But then that's scary too, because like they don't understand what's going on. And then at that time it was like when he got intimidated, he would swing at people, but he was moving in slow motion, so he was missing, and it was just a mess, and I was scared for that. But eventually I caught an officer that was really nice, and he went out of his way and came back and gave me some information for this. I don't remember the name of the program, but it was like an 800 number that I could call. By the way, the whole time I was on with United Way 211 trying to figure out any kind of help. You know what I mean? And so they gave me this phone number, and I called them. They came to our house and evaluated him. And then that's when the evaluation forced him to be able to be checked into the Anchor Hospital facility without insurance because of that recommendation.
Okay. And then treatment started, and
Yes.
we're in this much more stable situation.
Yes, and ever since treatment started, we have had no problem.
Good. And he still stays with you?
Yes, he lives with me full time.
And he can stay there?
Yes, he can stay there.
Okay. All right.
He's like a part of the team. I need him at the house. I need his help with his brother. Like we work all,
What's wrong with his brother?
His brother is only 8. I had them 17 years apart.
That's a big range.
Yeah.
Okay. So he helps keep track of the little guy?
Yeah, when I'm working and stuff like that.
All right. And what do you do?
Right now, I work for Hertz Car Rental, moving cars back and forth, and I'm currently in school as well. And I generally work in the personal injury industry, but I want to become an attorney myself. So I took this other job so that I can focus more on my classwork.
What does it mean to be in the personal injury business? Like you go out and break people's legs?
No, so I was more on the medical end. So I graduated with an associate's degree in science, and I was a certified medical assistant. And so I got into working for personal injury clinics.
Okay.
And then basically my last job was I was working before parking cars. I was working for a medical funding company that funded attorneys' offices and medical offices and people, like if you get in a car accident or something like that, you come to me.
Familiar with that industry. If you become a lawyer, don't become that kind of lawyer.
I want to be that lawyer. It's easy. I just want to sign papers and just keep it moving. I don't want to go to trial. It's just like.
Okay. All right. Well, this is about your son, but I appreciate you, your passion for him and being there for him. It's probably what made the difference. So I better understand that in between time, and even more so, I'm comfortable that everyone has come together to help lift him up in this difficult time. So thank you.
All right. Thank you. Thank you for hearing me.
You bet. Ms. Wood?
I would just ask that the court hear from Mr. Davis.
I will gladly hear from Mr. Davis again. Let's get him on there. Hello, Mr. Davis. How are you doing, sir? I appreciate your patience. You have been waiting and waiting, but you are that kind of guy.
Thank you so much. And the good thing about this is being in your courtroom, I get a chance to learn so much about the law, the language of the courts and all that. So it's always good to hear from you and how you manage a courtroom. So thank you for that, Judge. I've had an opportunity to get to know Mr. Johnson for the past couple of weeks, and just hearing what he was allegedly accused of or whatever is shocking, because I'm wondering because I know with young men, he's at that emerging adult age. Every behavior has a codependency to it. And I was curious to know, what is the codependency to what he was doing? And so now we learned that it was some untreated trauma, untreated medical conditions. But Judge, he is by far one of the most amazing young men. When Ms. Woods called me about him, You know, I try not to get so caught up in what attorneys say about their clients because they are the defense attorneys. But he met every, I mean, he met every point about himself that she described. Young man that was disciplined enough to, number one, graduate high school as salutatorian and to go to college and play college basketball. So those type things that I measure, there's a level of discipline about him, nice family support. It is definitely, we communicate, his communication, his soft skills are amazing for a young man his age. And one of the things that he pointed out, which I would love for him to be a part of, is that should the court grant him this opportunity, we have a program on Fridays, which is called Our Space. That is for that elementary age young men, where I think Mr. Johnson's story, his journey, would be great to speak with that population. Also, to talk to that group of young men in the program who are not taking full advantage of their the medicines that their doctors require. I think his voice, a great asset to the organization, in addition to the course is going to allow him to come. He's done everything we asked him to do. There's a small fee associated with this. He's taking care of that. He's been in every class, every Monday class, Wednesday class, and on Saturday. So it's definitely a pleasure working with him, Judge. He's a gentle giant from the for the past 3 weeks.
How tall are you?
6'8".
6'8".
Yes, sir.
All right. You are tall. We had to adjust the monitor just to basically get it up to your chest. Well, Mr. Davis, it sounds like Mr. Johnson's been accepted, and even though he is at that upper end of your program's age range, you see ways in which he might be able to contribute to people at the opposite end of that age range through his experience and some of the things that he's been through. Is that a fair recap of what you shared?
Yes, that is correct. And also to make note, we have several young men in the program that's aged out of that 25 limit, that's at that 26, 27 age range, who are doing a phenomenal job with us in helping us with that younger generation that we serve as well.
Okay. We may need to rename it the Next Level Young Men Academy so that you can fit these guys in.
It's actually called the Next Level Empowerment Center.
Okay.
Next Level Boys Academy is a subgroup within the Empowerment Center. So Mr. Johnson's in the Next Level Empowerment Center. He's a little too big to be a boy.
Good. I agree. All right. Well, thank you as always for being in a position to provide support where it's needed. I appreciate it.
It's a pleasure.
All right, Mr. Johnson, anything you want to add? You've been listening very patiently and standing pretty still. Anything you want to add to what you've heard?
No, Your Honor.
So my question is, I don't know if there's an easy answer, but I'd like to hear whatever you have to say. Why should I not worry that something like this is going to happen again in the next few years? What's different now than if we go back to December of 23 and January and February of 24, when this stuff was happening? Why is it not going to happen in 6 months?
I'll say the biggest motivation for me would be my little brother and the effects it had on him and how he would be nervous and stuff when I go out the house and stuff like that. And just setting a good example for him. I actually want him to be a part of Mr. Davis's program when he get old enough, because it's a good group of young men, like well-rounded individuals. You got the cool kids, you got the not so cool kids, you got the people that's learning about entrepreneurship. It's just a good mix to be around in order to find your true self, which problems I had because I was always so deep into things. So like I'll be extra deep with the nerds or the basketball players or the street people. And at the time, I felt as if I didn't have anything when I came back from college and stuff, and I felt unaccomplished. And at the time when you're at your lowest, you fall on things that's like that you look up to and that you've been listening to and stuff like that. And then it just like I was just in that trance, just trying to find like some healing within myself.
Do you remember these situations, the carjackings?
I remember some of them. Like I could recall them.
Okay. Where'd you get the gun?
From a friend.
Both times. I mean, I'm assuming it has to have been a different gun the second time because you got arrested the first time.
Yes, both times.
Same friend?
I think it was only one gun though. I can't remember though. I can't remember two guns. I only remember one gun.
Okay, I don't mean you had two at once, like the Lone Ranger, but if there, you don't think maybe in the January, February, it was guns, it was just December?
Yes, sir.
And
Okay,
Judge, I'm gonna just hop in. So the first two, there is allegations of the gun. That was the same day. That February 12th incident, the Ford Escape, that was a security guard, and there's conversation in the police report where Mr. Johnson had asked the security guard if they have to carry guns as part of their employment. So
okay,
there's
got it. That's where he went up and asked for a job.
Yes.
Okay, got it. Okay. Well, Mr. Johnson, you have taken great strides from the low of these situations. I think you are understanding and beginning to accept that you've got an illness that requires medication so that you can be in a safe space. In some ways, it's not different from cancer. If you got cancer, you're going to do what the doctor says. And you've got a situation where if you don't take medicine, your mind's going to have you do some things that aren't safe for you or the people around you, where your mom has to run after you down the street. And you're not 8, you're 25. And so that's scary for her, and that's not real safe for you. But it seems like now, with the assistance of the doctors and the medication, that you are in a much more stable space. Which is good, and I'm not interested in disrupting that, but I am interested in making sure something like this doesn't happen again. I think that's where Mr. Davis comes in. I think that's where your family comes in. It's also where you come in, and you need to be real committed to taking the medication and doing the things you need to do so that we don't have a repeat of this.
Yes, Your Honor.
So I find there's a factual basis for each of your 4 pleas. I also find that your pleas here are knowing, meaning you've understood what we talked about. Any questions about anything?
No, Your Honor.
Okay. And voluntary, that means no one's forcing you to do this. I'm sentencing you pursuant to the Probation Options Management Act. Ms. Wood, can someone in my office sign the 4 indictments, or I think it's 3 indictments and an accusation?
Yes, sir.
Ms. Davis?
Yes, Your Honor.
And Mr. Johnson, can we electronically sign your name indicating that you're pleading guilty in all 4 cases?
Yes, Your Honor.
We'll do that. So what I'm going to do, Mr. Johnson, is sentence you, and I'll start, I'm going to go by the age of the charging document. So 24 SC 004963, that is the Ford Escape situation. I'm going to sentence you on count 1 to 10 years to serve 5 months with the balance on probation. Count 2 is 5 months to serve, and count 3 is 5 years to serve, but that's consecutive. This is what we call a backloaded sentence. And so right now, that 5 years to serve is about 10 years away. And if you do well on probation, then that sentence goes away. But it is something that I can leave in place that lets me feel comfortable that if we have a little slip up at all, you're around a gun, you're taking something that doesn't belong to you, I can just bring that count in, and unfortunately, we're sending you to prison. I don't want that to happen. That's not healthy for you. It's not what your little brother needs. It's not what your mom wants. But these things were dangerous enough and serious enough that I need that kind of safety out there, that we don't really have to have a whole much of a conversation. You know that if probation doesn't go well, then that sentence falls down and you're off to where you don't need to be. Okay?
Yes, Your Honor.
But if everything goes well and your probation ends early, then that custodial sentence turns into a suspended sentence. All right? Special conditions of probation. Number 1, take all the medication doctors tell you to take. So you're required to take all prescribed medication. Now, you may start taking something that gives you some bad side effects. That means you talk to the doctor and the doctor gives you something different. It doesn't mean you stop taking it.
Yes, Your Honor.
So if, hey, it's giving me headaches or my muscles are sore, the doctor needs to give you maybe a little less of it or give you a generic version or something different. But you don't quit the medications. Special condition number 2 is that you forfeit any firearms that were seized from you. Number 3 is that you complete the next level empowerment program. So you're in it, you need to finish it. You need to finish it successfully. If Mr. Davis unfortunately needs to let probation know that you got kicked out or you walked away from it, that's going to be a pretty scary sign to me that you're becoming a little disconnected from the support that I'm hearing you say you want. So make sure you get through that program. I don't think that's going to be a challenge for you. You have a lot of horsepower up here. You just need to make sure that you're able to use it. And I think the medicine helps with that. And then finally, you'll need to stay away. Do you live near Buffington Road or Flat Shoals?
My grandmother lives over there. She
Okay,
lives,
so
down the street.
probably don't visit your grandmother. Your grandmother should visit you because you need to stay away from all these gas stations where this stuff happened. Okay? And there may be a way to get to your grandmother where you're not messing with those gas stations, but just don't be in those spaces. All right? For 25 SC 002-872, count 1 has been reduced to carjacking or hijacking a car in the 2nd degree. And your sentence there is that same 10 years to serve 5 months with a balance on probation. And then it's all those same conditions. Take your medications, finish the next level empowerment program, and you forfeit anything that was seized from you and you stay away from that location. And then that 5 years consecutive is 5 years to serve, but it's only to serve if probation doesn't go well. It's one of those backloaded sentences, and I'll turn it into a suspended sentence if everything goes well.
Yes, Your Honor.
25 SC 002-873, the state reduced hijacking 1st degree to hijacking 2nd degree. There's an identical sentence, that 10 to serve 5 months, balance on probation, followed by 5 years in custody, all those same conditions. And then finally, this most recent case, get the accusation up here. That one I am simply going to say is 5 years to serve 5 months with a balance on probation, with the same conditions you heard me talk about. And all these sentences run concurrently. That means all at the same time. So the big picture is you're going to be on probation for the next 9.5 years. It's a long time. That's followed by 5 years in prison if probation doesn't go well. And I'd revoke your probation as well. But if probation goes well, those 5 years would turn into a suspended sentence, where the only condition is that you obey the laws of Georgia and all the other states and the United States. I'm not going to set a behavioral incentive date. Ms. Wood may have talked to you about that, but probation will come to me if things are going well at the appropriate time. I'm going to recommend that probation assign to you a mental health probation officer. That's an officer who is very attuned to the things you're working through and is fluent in medicine. And so if you and your mom are talking to this officer and your mom says Depakote, that officer is going to know, I know how that works. And you're taking 25 milligrams? That's a whole lot. Maybe we should do 20 milligrams. That person is not a doctor. It's just someone who knows the kinds of things that you're working through because of the mental health challenges that you have.
Yes.
That's a recommendation. I don't know that they'll assign an officer like that, but it sure helps when they do, because that officer doesn't look at you funny if it's right after you got your shot and you're like, moving slowly. Officer knows that that's a side effect, and that doesn't mean you've been smoking something you're not supposed to smoke. Yeah. Okay. I think I covered everything, but that was a lot. Ms. Davis, anything from the state?
No, Your Honor.
Ms. Wood, anything from you?
No, Judge, thank you so much.
If I make it a requirement of probation that Mr. Johnson live at his mother's house, they can always amend that. If there's a reason it's safe for him to have his own place, he can always, if everyone agrees, in particular probation agrees, he can live on his own now, and that's all safe and good. I'd be more comfortable if for now home has to be mom's house, Does that work for you, Ms. Johnson?
Yes.
Okay, so I need you, Ms. Wood, to get to Ms. Nelson that address so it's baked into the sentence. Do you live in Fulton County?
I live in East Point.
Okay, I ask only because that is where that defines where you have to report for probation. You've never been on probation before. You've got zero criminal history except for this mess. And so you'll be reporting to the probation office it's like a block from here. Okay. Ms. Simpson, can you give Mr. Johnson reporting instructions, please?
Yes, Judge. Mr. Davis is raising his hand before.
Oh, okay. I'm sorry. I wasn't looking at the screen. Mr. Davis.
Yes, I want to be clear about some things so that we will ensure that Mr. Johnson doesn't violate. That Buffington Road area is near our South Side campus in Union City. So either you can give him permission to go there only for class on Saturdays from 9 to 11, or he would have to take our virtual because we rotate locations weekly. First, third, and fifth Saturday, we're in Union City. Second and fourth Saturday, we're in the city of Atlanta. So he does have to pass that Buffington Road area to get to our Union City campus. So I just want to make that known to the courts.
I appreciate you flagging that. And I don't want Mr. Johnson to do virtual. I want him to be in person. And he can be on Buffington Road. He needs to stay away from those gas stations. So it doesn't mean he cannot visit grandma. It doesn't mean he can't get to your campus. But he shouldn't be caught on video loitering at the Chevron on Buffington. That's a bad space for him. And the store operator may say, there's that tall guy again who steals cars, and we don't want them going through that. So let's not worry about, I appreciate you flagging it, but it is A-okay for Mr. Johnson to go to the campus down there. Okay?
Thank you, sir.
All right, let me make sure there are no other waving hands. Nope. Ms. Simpson.
All right, Mr. Johnson, what is your zip code?
30344.
All right, so your reporting date, excuse me, my apologies. Your reporting date will be October the 6th, and you're going to report to the Atlanta office. That's 276 Memorial Drive, and that is in Atlanta. And the zip code is 30303. You will report to that office at 8 a.m. that Monday morning.
Yes, ma'am.
Don't miss that first appointment because all they'll do is send me a warrant saying, where was Mr. Johnson? So make sure you're there.
Yes, sir.
All right. Any questions about anything?
No, Your Honor.
All right. Good luck.
Thank you, Judge. Thank you, Mr. Davis.
Thank you.
You're welcome. You're so welcome.
You too, Mr. Davis. Appreciate you gave us most of your morning. Go do other things.
Yes, sir. Thank you.
All right. Bye-bye.
Okay.
All right, folks, we are on break until 2. I think you're done, Ms. Wood, but appreciate it. Ms. Davis, I'll see you at 2 for the nail plea.
That's Ms. Willingham.
Oh, I won't see you at all. You have a wonderful weekend. All right.
Yes.
Can you please text me the address and the contact number, please?
I'm about to send you an email before I leave.
Yeah.
All right. So Ms. Rivers and Ms. Simpson and Ms. Gordon, I will see you all at 2 o'clock for one last plea.
Am I coming back to this same link, Judge?
Yes, I'm leaving this up. I'm just going to mute it here in court.
Okay, thank you, Judge.
You bet.
in and around your eyes. So you should not try to, because you could
All right. You're Mr. Nail?
Yes, Your Honor.
Great. I know who's sitting next to you. Mr. LaScala, good to see you.
Nice to see you, sir.
Thank you for your work with the Young Men's Service League. That was a helpful presentation to potentially wayward youth.
I love to terrify some of those women, Judge.
Yeah, well, it worked. I got an earful. So we're here, I believe, because Mr. Nail, you are prepared to enter a plea in your case. Is that right?
Yes, Your Honor.
Okay, then what I'm going to ask you to do is to come up with your lawyer, Mr. LaScala, to the podium. Mr. LaScala will be where the wooden podium part is. You'll be over where the microphone is. And Ms. Willingham is going to come up to the witness stand because my court reporter is virtual, and that way she's going to be able to see and hear everyone. Ms. Rivers, are you good to go?
Yes, I am.
Great. Then we will get started. This is 25 SC 003219, State versus Michael Nail. Mr. Nail is charged with aggravated assault and obstructing a person making an emergency telephone call. Mr. Nail, in a moment, Ms. Willingham will put you under oath and then ask you a series of questions about your rights as well as about the case. You should answer the questions truthfully and completely. If at any point you want to talk privately with Mr. LaScala, let me know, and you guys can step back from the microphone. If you've got questions for me, let me know, but I need to be comfortable that you're understanding what's going on throughout the process. I think you will. None of this is meant to be confusing, but if there's part of it that's not going the way you thought, call a timeout so we can make sure you're following what we're doing. Will you do that?
Yes, sir, Your Honor.
Excellent. All right. When you're ready, Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Please state your true, correct, and legal name.
Michael Christopher Nail.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you and how far have you gone in school?
I'm 47 years old and I undergraduate degree.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
I have. Yes, ma'am.
Do you need any more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Absolutely.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I believe he does.
Have you reviewed the indictment in this case?
I have.
Do you waive formal reading of the indictment?
So waived.
Has your client been arrested on these charges?
He was.
The state is unaware of any outstanding warrants related to these charges. Do you or your client know of any outstanding warrants related to these charges?
There are no outstanding warrants.
Mr. Nail, do you understand you are entering a guilty plea to battery family violence, which has a minimum of 1 day and a maximum of 12 months, and I'm sorry, Your Honor, count 1 is being reduced,
I gathered. All right.
and count 2 is going to be null price, and just for the purposes of the litigation manager, that reduction is going to be under OCGA 16-5-23.1 subsection F. Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 12 months probation, complete family violence intervention program, and complete 40 hours of community service?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and the court can sentence you to the maximum sentence and can
on each charge and can run that sentence consecutively or one after the other.
I am aware, ma'am.
Do you understand that if you do not accept the court sentence, you may withdraw your guilty plea?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to a revocation for the balance of the sentence?
Yes, ma'am. Well aware.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
I do. Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
I am aware of that now. Yes, ma'am.
Do you further understand because this is a family violence conviction, if you are found in possession of a firearm, you could be charged federally?
I've never touched a gun in my life, ma'am. All good. Yes, ma'am.
You can add the part about not touching a gun, but it's a yes or no question.
Sorry.
It's all right.
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you would have the right to a trial by jury? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
Repeat the question, please, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am. Not at all.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charge of battery family violence in indictment 25 SC 003219?
Guilty, ma'am.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
I am aware of that now, ma'am. Yes. Thank you.
Do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Your Honor, if this case were to proceed to trial, the state would expect to show that on August 25th, 2024, officers responded to 460 Brown Thrasher Court, Alpharetta, Georgia, in Fulton County. Upon arrival, officers spoke with Marcela Hernandez, who informed them that her boyfriend, Mr. Nail, and housemate of approximately 9 months, wrapped both of his hands around her neck and started to apply pressure during an argument. Ms. Hernandez told officers that they were arguing over something pertaining to her always being on her cell phone. Hernandez added that while the defendant had his hands around her neck and was applying pressure, he stated 3 times that he would kill her. While describing the incident, she made a motion with both hands to the front area of her neck in an attempt to show officers what Nail did to her. No bruises were observed.
That's it?
I think that's enough for.
Because there's something about a 911 call, but I guess you dismissed that, so we don't need to get into
And
that.
I can, if Your Honor wants to hear it, I can.
No,
still go into it.
you don't need to provide a factual basis for that. I am curious, you had as conditions of probation, complete a family violence intervention program, do some community service, nothing about contact with Ms. Hernandez, whether no violent contact, none at all. Where are we with that?
And Your Honor, this case was actually negotiated before me. So I am not sure why it wasn't included. I do see the notes, however, based on the notes, I do believe it probably would be no violent contact. It appears that Ms. Hernandez did contact our office and at some point stated that this went further than she wanted it to.
This meaning the prosecution?
Correct.
Okay.
But there is no note as to whether or not she wanted it to be no violent contact or no contact.
All right. Anything else?
And that concludes the state's portion.
All right. Ms. Gordon, thanks for sticking with us this afternoon. Do you have any criminal history information on Mr. Nail?
Yes, Your Honor. The defendant has 2 arrest cycles beginning in 2000. Last arrest was March 20th of 2013 from Cherokee County. DUI, driving under the influence of alcohol, possession and use of drug-related objects. The DUI received misdemeanor conviction July 26th of 2013. Possession and use of drug-related objects was null prost. No felony convictions listed, nothing further, Your Honor.
All right. Thank you, Ms. Gordon. And that is it for us today. I appreciate you filling in. Have a great weekend.
You too.
Mr. Lascala.
Judge, thank you so much. For the record, it was no violent contact. I had an email with the original offer. So Ms. Hernandez has been intimately involved in this since it happened. She's contacted me multiple times. She's contacted the district attorney's office. She's come down here in person saying she wanted the charges dismissed. But in any event, we do believe this is a fair resolution for the government and for my client. He has 2 prior cycles. They're both driving related. There's no indication whatsoever that there's any violent, history whatsoever. This is a negotiated plea, Judge. He is qualified for first offender, which we will be asking for. And I did go over both the benefit and the burden of first offender. And he still wishes to move forward with that. I don't anticipate any issues whatsoever. The DVIP is going to take a minimum of 6 months if he started that today. So that's 24 weeks. And then the community service, you can knock out pretty quickly. So the only other request, which wasn't actually negotiated, but I would ask that he either terminate it after he completes the special conditions or a minimum that it goes non-reporting after he completes that. There's nothing in his record that would indicate that this is a pattern of behavior, Judge. And again, for the record, I've talked to Ms. Hernandez multiple times, and she's upset it's even gone this far. As the district attorney had said, she did make this allegation. She was upset at the time, and there was literally no physical evidence whatsoever that any of this happened. They did not come to the house. They met at a fire station. But in any event, there was an argument. Mike takes responsibility for that. And it wasn't a strangulation. It was worse. It was a family violence. But it shouldn't have happened. And he came to my office and was sorry. And they have a relationship. And I think hopefully they'll continue to have a relationship. But at the end of the day, he'll do whatever's required.
Okay. Mr. Nail, are you and Ms. Hernandez still in a relationship, or how would you describe that situation?
Tell the truth.
Since this incident, sir, has happened, I mean, we have, she's Colombian, right? So her native language is Spanish. We have a little bit of a slight communication issue because mine is English, hers is Spanish. Miscommunication a little bit through like texting and whatnot. That's our only fault. Our whole reasoning for this incident was just strictly, her jealousy and whatnot of me being on my cell phone. None of this would have called, but okay. Yes, but we are in a relationship, and I mean, basically, we are completely fine. We're friends. We're not in any way, shape, or form in any argument. There was so I'm not sure.
Do you guys live together right now?
No, we don't. No,
okay.
Because ever since this happened, she had to move out shortly after. She lives in Buford. I live in Cumming.
Okay.
We're all fine, but
Talk on the phone?
No, we don't.
You text?
We basically just we don't text, sir. No, we basically just we see each other every so often. Just I know where she lives. She knows where I live.
Okay, so you're in contact it's not a bad thing. I'm just trying to understand. I don't want a condition of the sentence to be something that interferes with an ongoing relationship if there is in fact a safe and healthy ongoing relationship.
Right.
But if you haven't thought about this woman since August 25th and don't want to be around her, then I should say while you're on probation, don't be around her. So that's all I'm asking about, not whether it's a super close relationship, if you hold hands or anything, that's your business, not mine. But it sounds like you two still interact.
We still interact, yes, sir.
And you would like to be able to continue to interact while you're on probation.
Just become friends. That's right. Yes,
Okay.
sir. We've learned a lot over the past year and so forth. But yes, we would like to interact with each other if that's.
And I've spoken to Mr. Hernandez. That's absolutely correct.
That's her preference also.
Yes, that is.
Okay.
And Judge, I scrolled down to some of the earlier notes. It does look like she stated that she wanted to keep in contact with the defendant.
Okay.
Thank you, Judge.
Mr. Nail, what do you do for a living?
I do two different types of jobs, sir. I work in the food industry, and I also work in sales with in regards to merchandise, sports memorabilia, autographs and such. So it's two different sales jobs that I just do part-time.
Okay.
That I'm going to get amped up a lot more once today is finalized, because I was trying to figure out what the situation was here before.
Sure. So food industry, does that mean that you own a restaurant, that you work at a McDonald's, that you bake cakes?
I serve wait tables, bartend. It's a little each, a little bit of each. So I've been doing that for 6+ years part-time, and then
you've got the sports memorabilia.
Correct.
And is that a brick and mortar place I could go, or it's an online?
Online, as well as we have our own office where all our merchandise is in Beaufort.
Who's we?
Just my fellow employees and all.
Okay. So it's a company.
Yeah, A&A Enterprises.
It's called what?
A&A Enterprises.
Got it. Okay.
But yeah, I mean, it's great, and I love sports, and so we're everything's going great. Yes, sir.
Excellent. Well, it's a good time of year to be a sports fan. There's a lot going on.
Right.
Mr. Nail, I know that Mr. LaScala has already talked to you about it, but I need to on the record, and that's about first offender. You qualify for first offender treatment. You've been arrested twice. It sounds like the DUI. Well, I'm confused. The DUI, did you plead to the DUI? What happened to this DUI in Cherokee County in 2013?
I that was guilty, sir. Yes, that was.
So how could we use first offender now?
Because of the traffic offense, you're not qualified to use a first offender on DUI.
I didn't know that. Meaning you're not allowed, but.
It's statutorily prohibited on a DUI case.
Okay, so you can then use it later?
On a Title 16 for sure.
If it's not if the DUI wasn't a felony, then he would still be able to use first offender.
Well,
You can't use, if he used first offender on a misdemeanor, then he wouldn't be able to use it ever.
I think it's because it's a DUI. If you had a family violence, well, then it would be a felony. But if you had a battery and you pled guilty to it, you could not now use first offender.
That's right.
It's the fact that it is a DUI and you were not permitted to take first offender, which makes sense in the DUI world. So you still have that in your hip pocket. So you qualify for it in a roundabout way. What it means is that this is not a conviction today. When you leave here today, you will be what we call a first offender probationer. If you're looking to work for someone else and they say, tell me about your criminal history, this isn't something you need to tell them about in terms of a conviction.
Perfect.
That's the good part. And if you successfully complete your probation, it stays not a conviction.
Yes.
The risk is if you haven't told the full story of who Mr. Nail is, and it's Jekyll and Hyde, and at night and you drink and you get violent, this and that. And I'm not saying you do. I'm just saying that this was the story. And 3 months from now, you get arrested again for getting into an altercation, whether it's with Ms. Hernandez or someone else. Your first offender probation could come tumbling down on you without a trial. You'd have a hearing, but there wouldn't be a jury. And the state's burden would be very low. We would work through, well, do I take away your first offender status? And could I really resentence you? With a misdemeanor, that's a lot less consequential than as a felony. But suffice it to say, you could lose that first offender status. It would become a conviction. And the remainder of your probation could all become incarceration. I don't see that as a likely outcome, but I would be remiss if I didn't say there is a risk to taking first offender status. For you, I think it's a very small risk, but you need to tell me that you understand there is a risk, assuming you do understand it.
Yes, Your Honor.
Okay, and understanding the risk and appreciating the benefit, you want to be sentenced as a first offender.
That is correct. Yes, sir.
All right, you understand first offender is a one-time usage. So if you get in trouble a year from now for another misdemeanor, like, oh, that one's actually a little more serious. Could I use the first offender on that? The answer is going to be nope, because you used it on this.
Yes,
Got
sir.
it?
I do. Yes.
Play the card one time.
For life, basically.
For life, right. If you are reincarnated as Fred Nail could use first offender on his first non-DUI misdemeanor. But for this Mr. Nail, this is your first offender, and you are choosing to play it now, correct?
Yes, sir.
All right.
Yes, Your Honor.
I find there's a factual basis for your plea, and that your plea is knowing and voluntary, meaning you understood what we were talking about. No one's forcing you to enter this plea. I will sentence you as a first offender. I will sentence you to 12 months of probation. Special condition number 1, no violent contact with Ms. Hernandez.
Yes.
Number 2, 40 hours of community service. You'll need to complete those in the first 6 months of your probation.
Okay.
And number 3, you will need to complete a family violence intervention program. As your lawyer mentioned, that's not one class. It's not a, hey, one and done. I sit down for 2 hours and kind of sleep my way through a lecture. It's a bunch of weeks. You will need to start the family violence intervention program within the first 30 days of your probation. You'll finish it when you finish it. When you have completed all of the special conditions and you have not had violent contact with Ms. Hernandez, I'm fine having the rest of your probation be non-reporting.
Excellent.
Mr. Lascala, can someone in my office sign the indictment on your behalf?
That'd be wonderful. Thank you, with permission.
Can we sign for you, Ms. Willingham?
Yes, Your Honor.
And Mr. Nail, can we electronically sign your name indicating your misdemeanor first offender plea in this case?
Yes, Your Honor.
We'll do that. You are going to be getting reporting instructions either through your lawyer or by way of a phone call or email from the misdemeanor probation people.
Okay.
Their office is literally across the street. I don't know that they'll make you even show up the first time. They may just to register and do intake, but typically it is a remote reporting, especially in your situation. With your lack of criminal history, it may well be dial in, but they'll need confirmation that you're doing these things that are part of your probation. Okay?
Your Honor, so the sooner I finish all this, the better, basically, more or less.
That's
right?
a great way of describing it.
Great.
Just know that the Family Violence Intervention Program is not all that compressible because it's a series of courses, and it's not like you could on a Saturday say, I want to take courses 1 through 7. It might be week 1 is one, and then week 2 is the next. So that's going to spread your probation out some, but in the interim, take care of the community service, no violent contact with Ms. Hernandez, and you're doing what you can do. When you get that graduation certificate or certificate of completion from the Family Violence Intervention Program, my bet is that everything else is in the rearview mirror and you'll be good to go.
One other question, Judge, regarding the family intervention program. From when I've called there in the past, I've been told that it has to be the same day, the same hour every week for 6 months. Okay. If that, I work every day. I can't commit
We get it.
Okay.
Yes, you guys can manage that. I don't know how that works.
Yeah.
But what I do know is that you need to complete it.
Yes, sir.
All right?
No problem.
All right. Thank you, everyone.
Thank you, Your Honor.
Do you have an intake for us, or usually in state court or wherever else, we either take an intake form and they call us, or are you putting the responsibility on me to contact them, or how would Your Honor like me to do that?
It's a good question.
Email him a copy of the intake form. I'm doing it.
Okay.
Right now.
Sounds great.
Yep. Ms. Nelson will take care of you.
Thank you, Ms. Nelson.
All right. If that's it, I think we're done for the day. Have a good weekend.
Judge McBurney, great to see you. Thank you.
Same.
Thank you, Mr. Judge McBurney. Appreciate it. God bless everybody. Thank you.
Thank you, Ms. Rivers.
Okay, Judge, have a good week and see you Monday.
Yep. See you Monday. We'll get started with our angry jurors. Have a great weekend, Ms. Simpson.
You do the same, Judge. Thank you.
All right.